Dismissed by the order of Lojima Court on 17th of August 2010.
When did you file your application?
I filed my application on 7th of September 2010.
7th of
September 2010.
2010?
My lord.
No?
No, restoration. Delay condone. Delay condone. After condonation of delay.
But your restoration application is not on record. The learned advocate representing both the parties are present. The department is directed to place a record of the restoration application. Being number, do you have
8196.
Huh?
8196.
Can 8196 of 2010, along with the record of the main appeal on the next date. Next date we fixed on. Now you have to give them some time to find out. 4th of August. Next.
I appear for the petition.
My lord, this much hearing, your lordship, and kindly change the matter any date.
Who is your other side? Did you serve notice?
Sir, this is the affidavit service. This is the disbursement of unpaid salary and further deduction to join in the nearest.
The pleadings are completed.
Yes.
Who is the who are the answering respondents?
The West Bengal Chemical Industries. There is a government undertaking company.
One indulgence, I appear for the respondent number 6, the West Bengal Chemical Industries matter. The matter comes up after a long time, since 2012. It was dismissed for default twice, restored, and it comes up. We need to take appropriate instructions, and we need to come back to matter.
No, it had been dismissed earlier on 2 occasions. So you want to get this time, I mean, after that you have mentioned, you want to further get it dismissed. For what have you filed it? For hearing or further dismissal?
For hearing, madam.
Because on the earlier 2 occasions it was dismissed, thereafter restored. So what's your intention? You'll continue or you will, you have just filed for the sake of filing the restoration application, thereafter?
No. My lord, I let the matter be heard, my lord, in presence of the opposite party, my lord.
So, my lord, I would like to, my lord's leave, would like to indicate this. My lord was filed in 2012, when my lord the petitioner was in service. Now, my lord, in 2025, it appears to be the petitioner would be above 60 years of age.
No.
So,
October. Next October, my lord, he will.
Anyway, I mean, I'll fix a date. You
have to
appear,
exchange
and do you have a copy of the petition?
I do, my lord, but we will have to, I believe, we will have to exchange affidavits on this because there was no previous.
But he says the pleadings are completed?
Pleadings are completed. No, there is no opposition, my lord.
There is a direction, but no, my lord, no.
So then when I asked you, sir, you said yes.
Misunderstood, my lord. My junior, my lord.
When was the direction for filing affidavit in opposition? In any case, sir, you filed the affidavit in opposition on the next date. The learned advocate representing the petitioner, as well as the respondent number 6.
Respondent number 6.
Are present. The affidavit of service filed by the learned advocate representing the petitioner be kept on record. Next date be fixed on 12th of September for filing affidavit in opposition by the respondents. In the meantime, sir, you serve afresh on the other respondents. The learned advocate representing the petitioner is to serve a fresh notice upon the respondent number 225. 125. Respondent number 1 to 5 intimating the next date of hearing, file an affidavit of service to the defect.
ठीक है, my lord. Lord, मतलब I may be मतलब liberty to file.
But first,
reply,
let them
reply.
file. Let them file.
If reply, my lord, affidavit in reply.
They will file the affidavit in opposition. There are other respondents also. They are not on. They are not before the court today. So you will have to file a comprehensive one.
Yes, ma'am.
5 and 6 are together.
No, my lord. I appear for 6 only, my lord.
So who is 5?
5 is, my lord, the managing director, West Bengal chemical
Director.
industry.
Yes, the 5 and
Then-
6 should be, but I
Then you should
to
be
still-
appearing for both 5 and 6. Anyway, you get the clarification and then file it on behalf of 5 and 6.
And I have to serve notice 1 to 4 then.
remaining respondent.
Remaining
Next.
respondent 1 to 4. 1 to 4.
1 to 5. You have not been engaged on behalf
Not
of
yet,
5.
my lord. Not yet.
So you file,
I shall serve.
you serve upon respondent number 1 to 5. Next.
Lordship, this is, I am for the appellant, Lordship, this is railway claim, railway accident claim case, Lordship. Lordship, last occasion, Honorable Justice Subhendu Samanto, Lordship's direction for LCR called for.
Did you serve notice?
Lordship, Talabana Sar, but no one appeared, Lordship, and then issue notice. Administrative.
Oriental Insurance Company, Mr. Singh, can you be of any help?
Eight three numbers.
The
Oriental.
learned advocate representing the appellant claimant is present. None appear to represent the. No, sorry. It is Union of India. No. To represent the railways,
Yes, Lordship.
respondent
Lordship.
railways. আচ্ছা আদিত্য ওই রেলওয়েজ এর এক ভদ্রলোক আসেন না?
Lordships.
Next.
But I am on behalf of the appellant. It is the case of under 163A, the death case. Tribunal already granted 3,26,000 on 1,74,000 we paid with 6% interest. Paper book we have filed. Kindly make it short.
Submission of learned advocates representing both the parties. Next date we fixed on 1st of September for orders.
Obliged. ma'am.
Next.
I served notice.
Yes, sir.
I have served notice in 2021.
Huh?
In the year 2021, I have served the notice.
In the year 2021, you have served. And in which you are today?
And nobody
Learned
informed me
advocate
which are
representing the
Let me
the thing,
it is not
the
putting on-
National Insurance Company Limited. Number 5. The learned advocate representing the appellant claimant is present. None appear to represent the respondent insurance company. Let the matter be fixed on 30th of July, so that somebody at least comes and appears. Thereafter, we'll
much
proceed. Next.
Thanks, my lord. I am for the respondent insurance company. This is for correction and already my learned friend and I have,
Correction. What
yes.
correction?
I've given the correction to my lord
Okay.
court officer.
Next. Next.
Lord, is insurance appeal along with the cross submission filed by my learned friend on behalf of the claimant. There has been made absolute note on the last occasion. My learned friend, my lord, had
Who was to file the paper book?
I'll file the paper book, my lord.
No, this is fixed. This was fixed for recording the cross objection.
No, my lord.
No, it was not for the first time.
Yes.
For the first time before my lord's court.
So now what?
My lord, his stay is made absolute. My lord, on the last date, the direction was upon him to deposit his special messenger cost
I have
to bring the
deposited
lower court,
that.
trial court records. Lord, it has come in today. Your lordship will kindly issue direction for filing of paper.
You will file paperwork.
I'll file
You will
paperwork.
file.
Yes, my lord. It is
The-
ready almost, my lord. Any short date just for filing the
The
paperwork.
trial court records have been received by the department of this court. The learned advocate representing the respondent claimant seeks further time to file the paperwork and the same is allowed. Next date, 13th of August.
13th August.
Obliged, your lordship.
Deeply obliged, my lord.
Next. None appear to represent either of the parties. Let the matter be adjourned for the day. Next.
Lord, change is then scheduled for appearing for the first time. Lord, there is a condonation of delay application. My lord, there is no delay. I'm sorry, my lord. It's appearing for the first time. I was praying for my lord interim stay for your lordship.
Item number
Dos.
9.
Was there any delay?
My lord, no.
Huh? 202
My lord,
days. delay?
section 5, my lord, I have filed. My lord, the delay of my lord 187 days. As per my calculation. I'm sorry, my lord.
202 days.
I'm sorry, my lord.
2, 3, and 4.
Obliged to your lordship, my lord.
4 weeks.
4 weeks.
Issue notice, file affidavit of service. Next date. 16th of September.
16th of September. Obliged to my lord. Great.
Next.
Lord, item number 9.
Next.
I am for the respondent insurance company.
Sorry, my lord, in the matter, my lord, there's some delay in the matter. Like there's some delay.
How many days delay?
The delay of my lord,
The
39 days, I could not file the
the
application
learned advocate representing the appellant
by 2 weeks.
claimant is to take steps in removing the defects pointed out by the stamp reporter. Next date be fixed on 19th of August. The learned advocate representing the respondent insurance company is present.
Right.
Next.
My lord, this matter has come up upon my mentioning for correction, my lord. The paperwork.
Have you mentioned the correction?
My lord, only one correction. One of the
Paperbook.
yes, paperwork is there, my lord. Do you think?
Correction in what?
My lord, only one of the respondents, Mr. Pal, hasn't mentioned that he was a minor, and Aadhaar card is already there in the paperwork. My lord, only minor word has to be mentioned. Otherwise, they are not releasing the check, my lord.
Minor word has to be mentioned in the
Yes.
judgment,
Yes, yes,
but that has been mentioned in the paperbook.
yes.
Have you pointed out to the number,
Yes.
page and all
My lord, kindly comes to page 31 once. Page 31.
of the paperbook?
Yes. Yes.
31. Yes.
31. My lord will see respondent number 3, Orpon Ghada.
Huh.
And the fact that he is a minor is not mentioned here. Now, my lord kindly comes to page 36. This is the cross objections cost title. My lord will see cross objector number 3, Orpon Ghada.
Point all these things when the hearing goes on.
And my lord kindly,
Anyway, page 36.
my lord
Where
kindly,
do you want? In the operative portion?
yes, only in the ordering portion, my lord, one line.
এখানে না proper identification of respondent number 1 to 3 claimants, wherein respondent number 3
3. The supporting document is at
had
page
been a
58.
minor.
Deeply obliged.
The
my lord.
other had been a minor. The order dated such and such is modified to the aforesaid extent, with the other portions remaining unaltered. Next.
Deeply obliged. My lord.
My lord, I am appearing on behalf of the appellant. In this case, my lord, I have filed the paperwork in the department. So the direction was passed by my lord to place the paperwork before my lord. So that the came.
এসছে?
not yet received.
The paper book filed by the learned advocate representing the appellant claimant has been placed on record. Has she received a copy of the paper book?
No, Lordship,
You
not yet.
serve her a copy. A copy of the paper book is to be served upon the learned advocate representing
আপনি
the
সেটা আমায় তুলে আপনি আমাকে
respondents prior to the next date of hearing. Next date be fixed on 2nd of September.
My lord.
Next.
My lord, I am for the appellant, application for stay, my lord.
Your appeal is within time. The report of the stamp reporter mentioned the appeal to have been filed within time and in proper form. Let the same be admitted. Have you given the copy of the challan? 4 weeks to deposit the remaining amount. Issue notice, file affidavit of service, next date 17th of September. Next.
I appeal for the petitioner, my lord.
Yes, sir.
My lord, I have completed my argument. Also, I submitted my lord this argument. The
Yes.
petitioner before my lord.
It's today you are to submit. It's your turn.
Well, I have gone through everything.
কোনটা?
Now, এই তো অর্জুন রে তো
কমলা দেবী।
না 16 I am not. I am sorry, madam.
So who is representing Union of India here?
Mr. Chandri Alam appearing, madam. But the petitioner was placed under suspense. Charge sheet was issued by the deputy commandant. Petitioner paid for a listed document.
Yes.
Document was not agreement for long 6 months. No inquiry started. Deputy inspector came to the unit. He submitted the matter. The deputy commander was admonished in open before all the by the deputy. Sogotarai, my lord. Then commandant issued another charge sheet and says Sogotarai.
Has she come to court? She had a bereavement in the family, I was told.
Haven't seen her. But there must be a junior
Can I,
victim.
I'll fix it at
Yes,
2
yes.
p.m. Can you just find out whether she has
Very
come or not?
My lord, I have a case in the court number.
Let your junior be here.
My junior.
এইটা থেকে
And-
junior নেই, চান্দ্রজির সাথে। কে আছে? তার নামটা বলুন না।
नहीं देती आप। Well, 17, my lord.
Respondent.
That case, my lord, here, my lord, disciplinary proceedings and the criminal case was grounded on self-claim facts of and self-claim witnesses. My lord, ultimately, petitioner was exonerated from the criminal division bench, my lord. I prayed, my lord, that since the, as per the leading judgments, my lord, the departmental proceeding cannot sustain. He has to be reinstated in service, my lord.
Yes, sir.
My lord, earlier also, I
You wanted to?
yes, I made a
see the
submission with your
document?
lordship that yes, probably in this matter I have to concede certain point of law. But thereafter, I thoroughly gone through the thing. I find, my lord, here that so far the criminal proceeding is concerned, there what are the issues in the departmental proceeding? The issues are not same.
Show me.
In criminal case, my lord, it was under 302 of the IPC. Here, my lord, what happened in this writ application? They didn't disclose one thing, but they, my lord, prepared another writ application that was dismissed because they didn't disclose that the pendency of the earlier one. But in that writ application, they said that he has completed the fire training. Now, question is here, my lord, therefore the department made the charges here, 2 charges, that when he saw his wife, she is burning, 95% burnt. He was standing alone. Someone, my lord, he broke the door, he entered there, and he, with the help of the water, my lord, ultimately got the fire, my lord, off. Ultimately, that lady succumbed to death. Authority said that it was a mere negligence on your part. That had it been you are a layman, I could understood. But here you have your own training. Nevertheless, you were sitting there. And moreover, at the
Sitting where?
In the court, my lord, he was sitting there.
In the
In
court.
room, yes, inside the room, my lord. Then he stood up. As soon as the person came, he stood up. Now there was not a single burn on his, my lord, body. He admitted that yes, for 4 or 5 minutes I was standing there alone. It was his own admission. This is one aspect of the matter. Another thing is that they have taken a ground here that in the inquiry there was no presenting officer. Now up to 2011, in case of all the paramilitaries, BSF, CRPF, CISF, dear my lord, there was no provision for engaging any presenting officer. The after 2011, due to certain judgments, my lord, now we have changed the rule. Now here also, my lord, categories of judgments are there. Our Calcutta High Court, my lord, they are also relying on one judgment. Our Calcutta High Court full bench judgment is there. There it was stated that merely because the presenting officer is not there and the inquiry officer, he is making some question to the witness, it doesn't mean that the entire procedure is vitiated. It would be seen that whether there was any leading question or not. If there is any leading question by the inquiry officer, in that case, certainly the entire proceeding should be vitiated. Therefore, my lord, in this matter, unless your lordship specific order is there, my lord, the department will not give the, my lord, entire, my lord, record. Record is essential. Because from the record also, your lordship will find it, whether there was any leading question or not. So these are the two questions.
So you mean to say that the charges in the criminal case as well as the disciplinary proceedings are distinct?
Different. Yes, are different. So therefore, those
So let us-
tank or other judgments, those doesn't apply here.
Those charges must be here in the
Yes,
record
madam.
itself.
Charges are here. If your lordship kindly come to এদের পেজের সঙ্গে আপনাদের এই যে এইটা কোন পেজে আছে দেখান না
আমাদের এখানে তো নেই
কি নেই কি ফাইনাল অর্ডারটা
criminal case charge sheet.
In the petition, you
Criminal.
must have annexed those charges, sir.
Yes, ma'am, that's page 38 for it prison. Page 37 and 38. It is not filed before
আমার
charges.
সাথে নেই।
While strongly burning inside the room of their hired accommodation at Sinamara Jorhat in front of the Constable Arjun De was crying for help. Constable Arjun De has shown apathy in dousing the flames. He also displayed very unpleasant act when the neighbor such and such rushed to the house of Arjun De to rescue his wife. The said Constable Arjun De did not open the door. Finding no alternative, such and such entered the room by kick open the door and doused the flames. The above act on the part of the Constable Arjun De amounts to gross negligence and violation of ethics of life. So this is the only charge.
Article charge on 37, 33, the charge is the same, madam. Page 37, 38.
No, there was another charge in 37.
Charges are there.
37, 38. Same, almost.
And what about the charges in the criminal case?
Well, that
Like that needs to be placed.
Criminal case
That
is not
needs to
here,
be
madam.
seen.
It has not been actually
Well,
when the
judgment-
matter was filed. at
judgment
that
of the
time it
criminal
was
court was
pending.
with me, my lord. Also.
I should be
Go
given a
ahead.
copy.
I'll give, yes, I'll give.
So you get the records and let
Yes,
him
yes.
file this in the form of an affidavit. The charges should be more or less same. Anyway. देखिए तो अब ये The learned advocate representing the petitioner claimed that the charges in the criminal case instituted against the petitioner are similar to that of the articles of the charges framed against the petitioner in the departmental proceedings. It was further submitted that the petitioner had been acquitted of the charges in the criminal case and correspondingly should be exonerated from the disciplinary proceedings instituted against him. Full stop. The learned advocate representing the respondent, you are CISF,
Yes,
CISF,
yes.
respondent CISF submitted after considering the documents and other materials on record. He had been of the opinion that the charges relating to the disciplinary proceedings were dissimilar to that of the charges framed in the criminal proceedings. He further sought for the records to be produced before the court. Accordingly, the concerned department of CISF
Yes.
is to place the entire case record of the disciplinary proceedings before the court on the next date of hearing. The learned advocate representing the petitioner is to file the judgment of acquittal of the present petitioner in the criminal case to an affidavit on the next date of hearing. Next date be fixed on 21st of August.
My
Yes.
My lord, I'm appearing in this matter with Bhudev Chatterjee, my lord.
He is appearing.
So all of a sudden you appeared.
No, my lord, you linked it.
Next.
Ma'am,
20, my lord. I could not prepare the reply, my lord.
You are appearing for the first
20.
time, sir.
Yes, ma'am. 20th, I have to reply file. No, reply has to be filed.
I'm praying for another day, my lord. I cannot do it.
You have the copy of the petition as well as the affidavit in opposition with
Yes,
you.
yes, ma'am. Yes.
What, sir? You were given such a long time to file the.
But I could not do my lord. So kindly. Oh, last chance, my lord.
Is she not interested?
I'm too interested, my lord. I should, if it's just last time, my lord, I'll.
It seems so. On the prayer of the learned advocate representing the petitioner, let the matter be fixed on 8th of August for filing.
My lord, September, my lord. My lord.
Why, sir?
Miss, I'm sure sometime, my lord.
So it shows your last date was on 22nd of May.
My lord.
Then? No, 4th of April. Thereafter it was, I gave you more than 3-4 months time, sir. It seems that your petitioner is not interested.
My lord.
You can't resume contact with her.
My lord.
She's not coming for affirmation. What is it?
But I could not,
Sir?
till today, I could not contact my lord.
The son who is the claim is that the younger son should be given compassionate appointment, but he has not been made the party. Maybe if he gets in contact with the son.
Anyway, I'll fix it as a last chance. If on that day you don't file, I'll dismiss it.
Some more time.
So then let it go out of the list. Next date be fixed on 12th of September as last chance, failing which necessary orders will be passed. We'll proceed without the reply then.
Yes.
Madam, my lord, I am appearing for the state. Actually, I am praying for not today. My land senior is engaged in number 20. On the last occasion, your lordship directed the petitioner to serve upon respondent number 1 to 4. They are the answering respondent, my lord.
এটাতে তো আমরা অ্যালার্টেড আছি আমি along with Mr. জয়ন্ত সামন্ত
I am for the Respondent Union of India
Yeah,
in 27.
কবেকার allotment এটা? এটা কবেকার allotment, sir?
2016
না, তারপরে তো ওটা চেঞ্জ হয়েছে।
No,
2023 আমরা allot
Who is appearing for the state? Who is the answering respondent?
Your lordship.
Yes, I am
You are
the
representing respondent number 1 to 4.
Yes, I am 1 to 4.
You are representing 1 to 4.
So, my lord, the issue involved in this application is relating to the
স্যার ওটা আপনি ওই দিন
inclusion of
দিন পর্যন্ত
scheduled caste, OBC candidates particularly, either in the central list or in the state list. That is the dispute in between. So the question is, he is in the state list, but appeared for the post of constable in the central government. So there, his case was rejected on the ground that he does not belong to central list. So, my lord, on this issue, my lord, the learned single judge as well as the division bench of this honorable court.
Sir, have you filed the affidavit in
Yes, yes.
opposition? Was there any earlier direction?
No,
You
the
filed.
matter is ready for hearing.
So that's what I'm asking. Is
Yes,
is the
that-
pleadings,
That
the
is ready
pleadings are
for-
completed?
Pleadings are complete. My lord,
Where is your senior?
he is engaged in
Go and call him. So you wait for something. Next,
my lord, kindly accommodate me one item number 4 is there. My lord. I'm just coming. My lord. Yeah.
yes, sir, your report.
Now, in a report I have received on last Friday at about 4:30 p.m.
So
Now,
report
I
is
have
in your
accept-
favor. The report is in your favor.
entirely except one point raised by my net senior friend. That NBST has not filed an affidavit, though their counsel is there. Now, Government of West Bengal, one officer has affirmed the affidavit. Now, pith and substance of the report is this. These circular are applicable for the government employee only. But this is admitted position. They have filed their opposition that government undertaking. Now, my lord, I have to say something by filing rejoinder, if your lordship permit, 1 week only.
Out of 4 memo, one argument relies upon 2016 memo, 2013 memo, 2019 memo. Out of 4 memo or government orders, that I have stated in my paragraph number 5 that only so far 2016 paragraph number 5. 2016 memo, so far these are the new documents annexed to its reply to my affidavit. 2016 memo of 1107/25/2016, it appears that there is no such rider, that the same is applicable only for government establishment. So according to us, it appears on behalf of Transport Department, it appears, and after discussion with the Finance Department, that yes, it is applicable to all casual workers, even undertaking. But so far the other memos he annexed and relies upon, there we say that there
Which
is-
memo is applicable to him?
that is 2016 memo. It is annexed to his reply. If you also kindly have a look, his reply on a 2016 memo, that is annexure after 2013. Annexure, that is page 18. At page 18 of his reply to my affidavit. Here also enhancement of emoluments or wages for those casual and related workers.
So you have in paragraph number 5
Yes.
mentioned to that 25th February 2016
Exactly
memo.
Page 18 of his reply.
So you are also relying on this memo
No,
number.
it is all these memos. May I tell one thing? The original writ petition prayer is for regularization of this contractual delimited casual worker. Now, in course of hearing, when my lord, we have filed our affidavit denying the regularization, he said that a bigger amount is being paid, and by way of filing his reply to my affidavit, annex certain documents. Those are all new documents. So I sought leave to file my short rejoinder or report dealing with those fresh documents. Those fresh documents are about 4 memo issued by the state government. All those memos, my lord, admittedly, with regard to my lord, the certain my lord, enhancement of emoluments of those casual workers or contractual workers. Now it appears, bearing that page of 16, 2016, all others for either for government establishment or for other workers, not for this undertaking. So,
But the 2016 memo pertains to non-government workers also. All.
But he says that not 2016, all are applicable because undertaking is a government establishment. I deny the same. He said
The other memos.
yes.
So how are you affected by that, sir?
Because of the reason. Initially, my learned friend, Mr.
Those
Jain,
the memos are prior to 2016.
Prior to as well as my lord subsequent.
no, we're not only, sorry. My lord, may I?
Yes, yes.
Only one thing, my lord. Kindly visualize the present case. My lord, we have been engaged in accordance with law in the year 1992. Now, long 32 years, we have been discharging our function. A group of employees has already been regularized. Now, initially, we say it is correct, Mr. Shane, that contractual stroke Miller daily rated worker. But subsequently, they say by issuing a memo that we are a casual worker. Now, there is a good number of judgment, your lordship knows, Milord, that they are duty bound to regularize our service, keeping in mind not only from Uma Devi's case. I shall place, Milord, if your lordship permit me next say, Arguti. Entire thing is this. Now, only one thing, a peculiar feature of this case is this, Milord. NBSC has managing director. They are silent. They kept mum. They did not file affidavit. কত নম্বর রেসপন্ডেন্ট দেখো তো Milord, but state, in one hand, say, I'm although grateful to Mr. Shane that he fairly Milord submit that 16 is applicable. I say, Milord, right from 2011 memo, 2016 memo, 2019 memo, Milord, applicable in this case. I will not consume your lordship's time, Milord, because I want 3 days time or 7 days. I leave to my lord to file a rejoinder just, Milord. Only one thing, Milord. I request Mr. Shane, he's a veteran lawyer. He knows much better than me, Milord. Advance copy I have received, not affirm copy. Affirm copy? What is that?
আমি তোমাকে অ্যাফর্ম বলতে গিয়েছিল বলে তোমাকে অ্যাডভান্স কপি দিয়েছি।
না,
অ্যাফর্ম
না।
কপি দিয়ে দেবো।
Ay, be.
একটা কপি। দুটোই ডিসঅ্যাপয়েন্ট কেন?
Aditya, record. Sir, you are representing NBSTC.
No, I am in this.
So now he's saying that you have not filed any affidavit.
I filed the affidavit
In the meantime.
Yes, you file an
Will
affidavit.
Milord further delay the proceeding?
No, no, by
on the
Milord, I am withdrawing.
the memo.
I am withdrawing, Milord, and skip up my point. Kindly excuse me, Milord.
no, if
You'll-
they can file, let them file.
I
Milord,
think
They will that will strengthen your case.
the next date of hearing, I think, my lord, he will be able to file a short affidavit.
Yes.
I think, my lord, whatever the affidavit, that will be
Right.
in the line of affidavit or stand taken by the state, because the state is the.
He can't contradict the report that you have filed.
So,
The report filed in the form of an affidavit in compliance with the order dated 28/3/2025 be kept on record. A copy of the same has been served upon the learned advocate representing the petitioner who intends to file a rejoinder to the same. Next date be fixed on 12th of August
12,
for filing the aforesaid rejoinder as
my
well
lord,
as
13 or 11, my lord.
11th of August.
My lord, I have got some personal difficulty.
Okay, 11th of August will do.
Lordship.
Rejoinder as well as affidavit in opposition to be filed by the respondent NBSTC.
My lord, only a favor I am praying before my lord. A copy of affidavit.
Yes, madam.
The copy of the affidavit in opposition to be served upon the learned advocate representing the petitioner in advance. Next.
Grateful.
I'm grateful to your lordship.
Lordship, I beg to appear on behalf of the Union of Indians Party, Lordship.
My lord, by your by your lordship's order dated 6th of May 2025, we have mirror submitted our written notes of argument. Today is fixed for the mirror. If there is any clarification, mirror.
Yes, I would like to hear him once.
Lordship.
I have heard you at length, so I want to hear him once.
Lordship, may I?
Yes, sir.
The petitioner was, as I've indicated before, your lordship, the petitioner was posted in NDRF, that is National Disaster Response Force at Digberia, lordship. While he was posted, there was a discrete inquiry being ordered by the superintendent of the petitioner on the fact that there were certain complaints received by the superior office or superior hierarchies of the petitioner that when the member of the forces were visiting the civilian area outside the campus, lordship, there were reported some incidents of I would rather use the term, there were some obscene remarks were passed. Same was the case when the discrete inquiry was directed. Two of the member of the force, that is one Sub-Inspector Gulab Singh, he and along with him one more subordinate officer was directed to keep a vigil when the force members visit the civilian areas. Now, during such duration, this petitioner was on, it is an admitted position that the petitioner was on leave. He was on 15 days leave. And while he was on leave, he was staying outside the campus along with his wife. Now, at that relevant point of time, they could see the petitioner has tried to pass some certain obscene remarks on certain girls who were walking beside the streets. Now, this was informed to the superior office and appropriate steps could have been taken. But in the meanwhile, the moment this was reported on that very same day, when the petitioner was in leave, he reported back, he came to the SO's mess, that is the subordinate officer's mess, where SI Gulab Singh was stationed, and he assaulted this subordinate officer who was basically a senior in hierarchy to the petitioner here in lordship. Now,
this reported incident of manhandling or assaulting his superior officer, this was further reported to the commandant of the unit and a detailed inquiry was directed, Lordship. In the interregnum, the commandant or the deputy commandant, I would rather say, the deputy commandant.
So you are totally on the facts.
I am totally
they-
on the facts,
Yes,
Lordship.
now they had raised certain points.
Lordship.
right? During the process of the inquiry, they were not allowed to represent themselves through, what is that called? The friend of the accused.
Friend of the accused, Lordship.
Right. Friend of the accused, you had
Lordship.
not given them that chance to get themselves properly represented. So what is
Lordship,
your reply to it?
I'll come to that, Lordship.
Let aside the facts. To emphasize on the points that have been raised by them.
Lordship.
Right.
Lordship. If I may first take up, Lordship, there was a notes which was handed over by my esteemed senior friend, Lordship. If I may follow the same
yes, same sequence.
Same sequence, Lordship.
Aditya,
This is a 2-pager short note.
Yes.
Lordship.
Yes. ঠিক আছে.
Lordship, 172.
Now it says, if you come to the second paragraph,
Lordship,
by an order dated June 27, 2013, passed by the counsel of the respondents was asked to obtain instruction as to why the petitioner's choice of a friend to assist the petitioner in the trial as communicated by letter dated such and such was not accepted, and one DS Kanchan was appointed as the friend of accused. Now this is the person of your choice, contrary to the choice of the petitioner. Right?
Lordship.
So could you have done it?
I will justify that, Lordship. Now, there has been, Lordship, admittedly 2 sequence of events, Lordship. Why I'm saying so? Because the moment this is the first choice of friend of accused was given prior to filing this instant writ petition, Lordship.
That is rule 51 or 52, is it?
That is rule 157, Lordship.
157.
157 of the BSF rules, Lordship.
Oh.
I have categorically dealt this particular instance in page 10 of my written notes of arguments at page 10, Lordship.
But that is not on record.
No, I have filed my written notes of argument, Lordship. That has been taken by your Lordship.
Anyway, you tell me.
I'll come to that, Lordship. Now, the first set of incident, what happened while the trial was initiated at the first juncture, Lordship, when the friend of accused was given, petitioner admittedly has provided 3 choice of friend of accused, Lordship. Now, all those 3 persons, all the choice of 3 persons were coming from the Western theatre. Lordship, if I may clarify, BSF, Border Security Force, has been categorized into 2 theatres. The Eastern Theatre, which consists of West Bengal and all the northeastern states, and the Western Theatre, which looks over the Pakistan border, starting from Jammu and Kashmir to Run of Kutch in Gujarat, Lordship. Now, all these persons were of a deputy commandant rank officers and were from the Western Theatre. Now, if a trial is being...
Now, let us be very specific. What is the role of a friend of accused?
Lordship.
What is the role of the friend of an accused, right? So, is it restricted to any particular command?
No, Lordship.
Or any particular place? It can be irrespective.
It can be irrespective.
If somebody comes from the western side or northern side or southern side, what is your problem?
Lordship,
can you restrict somebody? I'm asking you whether it's provided in the rules or not.
No.
As you are saying,
there has been an admittedly, Lordship, there has been a grey area in this. Why I'm
Grey
saying
area.
so? Grey area. Why I'm saying so, Lordship? Because 157 clearly stipulates
that a friend of accused, and so far in respect of
has to be from the same
no, there hasn't been mentioned anything so far in respect of the availability of the friend of accused. But when we are concerned, when the trial is commencing in a Eastern theatre, in the Eastern theatre, and
so you can't get somebody from the Western theatre.
Lordship has to, in that circumstances, Lordship has to kindly appreciate the fact that the exigencies of the officers who will be coming from a different theatre altogether will be a much more it has
So you are basically concerned with your convenience rather than the convenience of the
Lordship,
petitioner.
if I may add to this,
I'm asking you whether the friend of an accused has been statutorily defined to be a particular person belonging to a particular profile or a designation or a post or a place of posting.
Nothing has been mentioned.
Now, a friend of an accused can be a person or could have been a person not related to this service?
Yes.
Yes?
May I be permitted to place? 157, friend of the accused. During the trial of a summary security force court, an accused may take the assistance of any person, including a legal practitioner, as he may consider necessary. The intent of the legislature is very clear. When somebody would be, my lord, under trial, and he would be, my lord.
So who are they standing at the back like this? It is so. Ask him to sit somewhere else and standing in front of the court with. Yes.
My lord, the intent of the legislature is that any person who can assist to the accused person, because if the person will feel that I can share everything to a person, he would be the best person to guide him. Otherwise, if we think every time suspicious that somebody would be, my lord, his friend of the accused, I would not feel comfortable to share with my views, share everything to my person.
So that is exactly what I sought the clarification for. That whether a friend of an accused, as he's saying, has to be from a particular regiment, right? Where the petitioner had been positioned.
That's why, my lord Justice Dattu, at the relevant point of time, categorically pointed out that you appoint someone who has been chosen by the, my lord, the accused person, so that he will feel comfortable. But despite this, the, my lord, the institutional obstinacy is such, despite there being a specific order, that person never been changed.
No.
Okay, this is one point.
If I may clarify further, Lordship. Now, when
so we are not on facts.
No, I'm not on facts, Lordship.
I mean, there's
I am
hardly any
clarifying
scope for
Rule
reappreciation
157,
of evidence.
Lordship.
We are basically on the law points that has been raised
Lordship,
by the.
Lordship, I will further clarify
Have
157.
been raised by the petitioner.
Now, when we are reading Rule 157 vis-a-vis with the Summary Security Force Court, Lordship, we have to also bear in mind, Lordship, that during Summary Security Force Court, the friend of accused can not raise his voice, Lordship. He will merely assist the accused.
Who has raised the voice here?
No, I'm saying that during there are change of scenarios.
To say cannot act as an advocate.
Act as an advocate.
So nobody has acted as an advocate.
He cannot rather question. He cannot possess any cross question, or rather the mere thing which he can act as in that he can only advise the accused, because in Summary Security Force Court only the accused is permitted to cross question.
He would be there to only assist.
Right. That's
assist the petitioner in the course of
the hearing.
What is required to be done, and in which stage he has to put questions.
So this one point is clear.
My lord, my lord, the second aspect, this was the first aspect before filing the writ petition, Lordship. Now, after filing the writ petition, after the grant of stay, Lordship, by an order dated 27th of November 2013, his lordship, then was directed the respondents to proceed with the trial.
Yes, that you have proceeded.
That we have proceeded, and during the second leg of proceeding, the person whom the petitioner has requested, that is Shri D.S. Kanchan, Deputy Commandant, as the friend of accused, the same person was given as the friend of accused, lordship, and that is apparent from.
So they had to accept because you denied.
No, lordship. During the second leg of proceeding, the petitioner only requested for the DS Kanchan. We did not give DS Kanchan to him.
Okay.
Those three choice of friend of accused were there during the first leg of proceedings.
So you mean to say in the first instance they refuted, and on the second instance they accepted?
It is incorrect, my lord.
Sorry?
It is incorrect. It is incorrect.
Lordship,
the DS Kanchan has initially been appointed. That has been, my lord, agitated before this court by filing writ petition. Thereafter, when my lord Justice
Second time also he says DS Kanchan was
there. He has not been.
Lordship has.
So what happened? Then you conceded to it?
No. My fate was same, but the only thing which is categorically
did you protest against the appointment of DS Kanchan for the second time?
No, my lord, my lord, initially, since the order has already been given, it appears
it continued. It continued.
It continued. But it appears
it's not for the second time. It was just a continuation.
Yes, sir. Yes, sir.
Lordship, if you lordship,
don't confuse like this,
lordship, I have the documents, lordship.
So it was firstly instituted, thereafter stayed, and then asked to be continued, and the results to abide by the results of this petition.
Right? That the trial
is absolutely incorrect, lordship.
Shall not proceed with
your
the
lordship,
of the leave of
your lordship has the original file of the SSFC proceeding, lordship. If your lordship can kindly takes up page number 25 of that file, lordship, it will be absolutely apparent. Page number 25 and 26, lordship, of the original SSFC proceeding, lordship.
Where is the file?
Lordship, 3 files. তিনটে ফাইল
না ঠিক আছে আজকে
এটা এসএসএফসি
কোথায় গেছে আদিত্য? It was in covered files?
Lordship, all were in covered files, lordship. There were 3 files. One was the court of inquiry, the other one was the record of evidence, and the third one of the SSFC proceeding, lordship. 3 original files.
So they must have kept in safe custody. It's not there in the. No, it's there.
Lordship, I'm also having the same.
কোনটা বলছে
না এসএসএফসি না সিওআই প্রসিডিং সিওআই প্রসিডিং
এই দেখি আমি দেখে নিচ্ছি
এসএসএফসি প্রসিডিং
No, it starts with page 96.
Lordship, the pages are in descending formation. If I may point out, lordship, it is page number 26.
Is it written in red ink? Is it written in red ink, the page number?
Page number, and it has been circled.
Okay, it's in Hindi. Page 26.
26 and 25, lordship. One letter is of 16.
Yes, it is written in Hindi.
16/2/2014, lordship.
Is it this one?
If I may just point out.
এসএসএফসিটাই বলছিল তো
এসএসএফসি প্রসিডিং
এসএসএফসি বলেছে
last টা হবে last টা yes, which page?
Page number 26 and 25, Lordship. 26 is the letter requesting.
25 SSFC trial against such and such.
Lordship.
Constable Navneet Kumar Singh of second
Lordship.
is being held.
Page number 26 is
Now,
the letter
here
requesting.
somebody else has been appointed as a friend of accused.
My lord.
Yes, Shri Nishit Upadhyay, second in command of second NDRF, is hereby appointed as friend of accused for assisting the accused during SSFC trial, provided that he shall not examine or cross-examine witnesses or address the court.
No copy, nothing else. This is completely paper on paper.
But then who actually assisted him?
DS Kanchan.
But then you have issued this letter.
DS Kanchan, my lord, in record also.
DS Kanchan has been.
Then why? I mean, what is the intent of this letter? This order, it has been issued and you have pointed it out. It says so. It doesn't mention the name of DS Kanchan.
If I may have a look once.
My lord, I don't
It is
get
your
access in any
document. You have pointed out. It's go through it. You only referred to page 25. Anyway, I have given you a lot of time today because he himself is not. So you go through the records once again because it's absolutely contrary to what you said and what you did. If you had already issued an order appointing somebody else, then this person shouldn't have continued, shouldn't have assisted him in that capacity of the friend of an accused. Could he?
No,
Contrary to your own order having been issued by your department?
No, absolutely not.
Record continue.
Nitish Upadhyay. Lordship, page 26, Lordship. The same letter which has been signed by the writ petitioner, that is requesting Nishit Upadhyay to be appointed as a friend of accused, Lordship.
So if that be the case,
he has not been appointed.
No, he was appointed, but how come he did not assist him? Because page number 25 is the order issued by the Office of Commandant Second BNNDR of Horingata, West Bengal. It's there. It's there on record, sir. It's your record. You have placed it. So in this, he has sought for this person and the order was also issued. Then how come?
Lordship, give us some time, Lordship. We'll just verify the records once.
That is why I wanted to hear you again. Heard the submission of learned advocates representing the petitioner as well as the respondent. CISF, right?
Lordship.
CISF?
No, BSF.
BSF. BSF. Next date be fixed on 7th of August because it's going on 7th of August. You next. Sir, what was the track record of the petitioner?
Some time to give instruction, my lord.
You need time. I just want to know whether this was a single incident
That's for that.
or there had been earlier, incidents wherein his conduct had been found to be
I've understood. my lord.
unsatisfactory.
Lord, just I probably told him, Lord, Lord, so can you keep it at 2 p.m. or tomorrow, my lord? Right now, I can't say, my lord.
Otherwise, I've seen it, but I need this clarification. Ashwin, because nowhere you have mentioned that.
Yes, my lord. Not nothing, sir, definitely. Right.
You have not mentioned it anywhere.
It will also differ definitely. Past track report is not there.
On the prayer of learned advocate representing the respondent, let the matter be fixed on 5th of August. The learned advocate representing the petitioner is present. And next. Yes, you sought for an adjournment the other day.
I'm seeking for adjournment again today.
No, madam. That won't be granted today. I have given you a chance on the last occasion.
See the record. This is the first time that I've sought for the adjournment on my own personal ground. The petitioner will suffer irreparable loss without any fault of his.
So you continue. What is the matter?
I just need to brief. I just needed to sit with the senior. The senior appearing in the matter is Mr. Achin Majumdar. I could not sit with him. He's also held up in some other court, so I could not.
So this is not a.
I'm just
This is
saying
not
for
an
a-
excuse. You had asked for adjournment on the earlier date. I have granted you that.
Yes, Your Lordship, I know, but this is my fault. The petitioner should not suffer on my account. That's all I'm saying. Give me a day's time. That's my humble request before this honorable court. Just a day's time, Your Lordship. If you see, for past 1 year, since the time we have started, I've been briefed in the matter. Not one single adjournment has been taken. The record will speak for itself. But I was not in the condition to even step out of the bed. So I could not brief the senior in the matter.
On the prayer of the learned advocate representing the petitioner, let the matter be adjourned for the day as last chance.
I'm grateful.
I record that.
Madam, I'm appearing for the petitioner item number 43, Your Lordship. Lordship, this is a matter where the petitioners, there were 6 petitioners who are the retired employees of the Calcutta Street Transport Corporation. My learned senior friend is appearing. Lordship, in this matter, they opted for pension under CSTC Employees Death Cum Retirement Benefit Scheme 1990. But subsequently, as the pension was irregular at that point of time when they opted for pension, they withdrew the option by way of an evidence that we want to withdraw our option, so we don't need any pension under the said scheme. So, Your Lordship, this is the issue pending before Your Lordship. But my Lord, subsequently in 2024, Your Lordship, I have found one government memorandum.
No, affidavits have not been exchanged.
I filed similar matter fixed on 9th September.
September, Your Lordship.
Now,
Respondent.
you will prefer reply to this?
Lordship.
Affidavit in opposition filed on behalf of respondent number 3, 4, and 5. Be kept on record. The learned advocate representing the petitioner intends to file affidavit in reply to the same. Next state with fixed on 9th of September along with petition number.
WPO number 414 of 2017.
Sir, can you just write it in a slip and give it to him?
Almost identical issue in all
Identical.
cases.
So let us-
In that matter also, the affidavit is.
That the, my lord, there was also the prayer, the window be opened again so that we can also opt for pension.
And this matter,
In
Your Lordship,
Mustafa, they did not opt for pension that time.
that was
Now after retirement, they say yes, again let it be open. Whether that is admissible or not, permissible or not, that would be the adjudicating point also. Very short point.
So was there,
There are several
after
people
how
that-
many days or months or years
Lordship, in this
after retirement? When was the, as sir is saying,
Then to the last amendment was carried out in 2002 CSTC third amendment of that regularization.
And they
That my lord, that option window.
the writ petition in 2011. All these matters are of 2011, Your Lordship.
so during 2002 you were in deep slumber?
That is 2017.
In 2002, where were you?
Lordship, I will satisfy Your Lordship on 9th of September. Lordship, let it be given on 9th.
Now, in that matter, affidavit in opposition has been filed.
Yes, yes.
The earlier one.
Yes, pleadings complete.
Lordship. I'm grateful, Your Lordship.
Good.
Next.
Get.
Lord, I am for the petitioner. My lord.
Yes, sir.
Lord, they have just filed opposition report, and
where is the report, sir?
I have been given a copy.
What have you stated?
They have stated very nicely
Dual
that
marriage.
Dual
marriage.
Dual marriage.
Plural marriage. It's called.
my lord at
Plural
And
marriage.
my lord, the
No,
other thing is,
I-
he is not ready to sign any documents.
Which document, sir?
His retirement document.
my lord, first of all, I would submit that I will put a single question through your lordship to my learned friend, from where it will be established that the quasi-judicial authority has committed fraud within 2 minutes.
What?
Committed fraud.
Acha.
Within 2 minutes, I will establish it. My lord, I asked my learned friend to give a reply that on 1st of December 2014, when the alleged marriage took place socially, where the alleged marriage took place socially according to them, where the marriage was what you call celebrated, solemnized. This reply I need.
Yes, there is the point that the
Whether you have seen the second marriage to have been solemnized. This is what he is asking.
the fallacy of this question is, we are not saying that you have married. There is a written complaint on behalf of your alleged wife made to us.
Oh, that's right. But why I put this question? Because
you are denying your second marriage.
First marriage.
First marriage you are denying.
Yes. And actually, my lord, that's right.
At which, on which date?
Yes. According to
on
them,
which date?
On 1st of December 2000.
So he was in service at the relevant point?
Yes, more than
no.
10.
So there is a provision for the preparation of the service book at the very induction, the inception of the service.
In fact, taken, if I remember,
Was he married at that point of time?
No.
No.
He was not.
Subsequently, he was married.
Subsequently,
So
the complaint came after he conducted the second marriage.
So prior to that,
Prior to that, he did
his marriage was not disclosed.
Well, he had taken a leave, if you remember correctly, he had applied for a leave to get married.
So was he married or not? You don't have documents.
Well, till that point of time, we were given the impression that he was.
So now here, how will the writ court decide whether the second marriage was conducted or not, this and that?
For second marriage is.
I mean, the first marriage. I mean, you cannot usurp the role of a investigating agency.
My lord, the investigation was itself wrong because their only document is public notary. And in public notary, they
Now, have
say-
you received this report?
Yes, I have gone through.
You have gone through it?
Yes.
So do you have to say anything against it?
Yes, I got it.
Sir, what I'm asking you, will you file a counter to this report? No, though it's not filed in the form of an affidavit,
No,
sir.
well, this is from Tripura. These problems we are facing. In fact, my junior had instructed them to make it at least on a bond paper.
That also cannot
We
be
could not find any bond paper in this area. I could not even recognize the name of the place. Nolkata, Tripura.
But it must be in the map of India itself.
My lord, it is clear from their report at page 2. That according to the appellate court's order, I am entitled for this. That is my last pay drawn was 31,100. Basic pension was 1,500, 15,700. Retirement gratuity 2,000, 1,900, 800. They have not yet till date they have paid. EGIS 5,987. GPF so and so already paid. When? After 9 years. So, my lord, my point is this, that I am a pensioner, I am getting, I am entitled for the pension as per their.
You are a pensioner.
Yes, I have been dismissed from service, but.
No, you said you're a pensioner.
As I have completed 10 years of service.
If you are a pensioner, are you receiving pension?
I am not, they are not giving it. This is the thing.
So you can say that you are entitled to receive
pension. I am entitled to receive the pension. Grateful to your lordship. So for since 20th of February 2016, they are not giving it.
Yeah.
Sir,
you prepare yourself, sir. I mean, this is.
Signing the papers.
Who?
Which paper do you want him to sign? Sir, which are the papers you want him to sign?
Pension papers. They want to admit me that the first wife is my wife. But I don't like to admit that. So pending.
Who asked you to do that? Where is the document?
They have sent a document that is with them.
Have you sent a document? Have you forwarded any such directions?
Yes, my lord, but the report does not specifically says that possibly in my pension papers.
Have you issued certain directions?
Direction, what he says is possibly correct, my lord, because in view of the complaint received by it, we have said that
now who will check the veracity of the complaint? So have you done that simpliciter on the basis of a complaint? What are the contemporaneous documents or any ancillary proof?
Admission.
My lord, they say that on the basis of public notary, they have got married. On first of
public notary, sir.
Yes.
He does not deny the document.
Document I am denying.
He does not deny the document.
Wait, sir. You need not be so exuberant.
He does not deny the document.
Huh.
He denies the legal effect of that document. So whether he raises the question whether he is legally married or not. He does not deny the event that he took that lady and got married. He does not deny that.
My lord, it will be clear.
But in any case, sir, public notary cannot be it cannot be an evidence of a valid marriage.
Well, if he wants to file any exception, let him file. Otherwise, we will make arguments on this. Whatever documents there are.
Yes.
And unfortunately, even the first wife has not even been made a party. First wife
was not made a party.
Not made a party in the
because
they are not claiming her to be a first wife.
Yes, and not only this.
That you
court of inquiry.
He doesn't
are made on any person.
Called my valid wife. They have made the court of inquiry. They have not met him party, they have not heard him. So he is my valid wife and by registered marriage, and they have gone up.
So what have you done? First of all, you married and then threw her out and got second marriage.
No, my lord, my lord,
Legally done.
my lord, here.
Then from where did that notary come into existence?
This is a
Maybe it has no legal effect, but what about intent of it? Why did you get into a notary public document?
My lord, this I submit.
Yes.
That from the
You married first and thereafter, now you are denying.
No, my lord. My lord,
What
here
no?
the happening is this, that on in the public notary.
And why did the wife did not? If the first, anyway, the court should not say, but yes, should have taken recourse to law in a different forum. That should have been better rather than coming here, because it's a question of status to be determined.
To complain which after complaining, possibly she has not taken any
steps
in civil court or otherwise.
Anyway, sir, I'll fix up for argument, and if you want to add on to this or controvert this, you can file any documents, sir. Okay. The report filed by the learned advocate representing the respondent. So, what is the department?
Border Security Force.
BSF. Be kept on record. A copy of the same has been served upon the learned advocate representing the petitioner. A filed dhorun. Next date be fixed on 22nd of September for final hearing.
If it is possible, August, my lord.
No, sir. I'm sorry, sir. Next.
22nd September.
2nd September.
Next.
Well,
22nd of September.
My junior has some from 21st, my lord, or 24th.
21st is a Saturday. So 19th of September?
19th.
Grateful to Lord.
I am for the CCC. Last of the lordship directed to sample a copy of the lead petition.
Petition, my lord. Read petition, my lord, as with but one application, my lord, for expeditious hearing that is pending, but it has got, my lord, no relevance now because the matter is appearing for hearing.
Have you served them a copy of the petition? Serve him a copy of the petition.
Well, they have filed, my lord, with no opposition.
You have filed it? Then why are you seeking?
My application is not sharp.
Which application?
Application for, my lord, expeditious hearing.
No,
that is, my lord, not relevant now because now the matter is appearing before lordship for hearing.
Opposition ta kothay ache?
Reply service kora hoye. My lord, may I file a rejoinder?
Reply.
1 second, sir. Huh? Application er kotha bolchi na. Affidavit in opposition is not on record. You might have served them a copy but did not file it in the court.
Next date
Did you file any report in?
On a old matter, I have not recollect, my lord. File is not traceable.
File is not traceable. Lordship, kindly give me some time so that, my lord, maybe that everything is ready, but it has not been filed.
So if you want, you can go through the record. He says he has filed the affidavit in opposition, but here there is a report in the form of an
Why, then that means, my lord, that was the order of the court. Possibly that is why, my lord, instead of affidavit, report in the form of affidavit. Because in most of the matters, my lord, the order usually, my lord, passed in that way. And report contains the entire, my lord, whatever the stand taken.
No, it was on 4th of September 2017.
I see. Then
the managing director, respondent number 2 hearing is directed to file a report in the form of affidavit either by himself or by any official. So probably that has been filed. Yes. So now he intends to file the rejoinder to it. There was a direction to file a rejoinder also subsequently. So if you are filing it, it can be kept on record. You serve them a copy.
I think I have served, my lord.
Are you filing it today?
Yes, sir.
File it.
Extra copy.
The rejoinder
I am handing over the copy, my lord.
to the report filed in the form of an affidavit by the respondents NBSTC, comma, filed by the learned advocate presenting the petitioner be kept on record.
No, English, not Bengal State Transport Corporation.
Next date we fixed on 3rd of September for hearing.
Mild.
Next.
Deeply obliged.
Get.
Well, in this matter, we were directed to file an exception to the report filed by FCI, one of the respondents. What FCI has done in its report is that they have cast the onus on the central government. In fact, the language is, the decision in the instrument lies with pay and accounts officer. So, after much attempts, we are able to contact the ministry, relevant ministry, food and supplies. What they did, they sent officers of FCI to instruct me. Officers of the FCI have come to me and stated their stand. They are not able to help me with the stand of the Union of India. Recently, I received a mail that we are supposed to work on the instructions of the officers of the Food Corporation of India. I'm praying for some more time to write to them. If they say that Food Corporation of India will instruct me, then I will.
But then who is representing Food Corporation?
Mr. Kamal Chattopadhyay.
Ask him to come because he will be in a better position to reply. Ask him to come. Pass over. Next.
Madam, I am paying for the petitioner, Your Lordship. Your Lordship, this is a matter regarding the regularization of the service of the employee of the Calcutta Street Transport Corporation. Your Lordship, on the earlier occasion, my Lord has directed me to file an application, including the DIG, West Bengal, to be a party respondent to Your Lordship, and that CAN application is pending. So, Your Lordship, CAN 1 of 2025.
When did you file?
I filed it on 18th of July.
Copy service করেছেন?
হ্যাঁ।
State কে দিয়েছে?
State কে দিয়েছে।
My lord,
So,
what is
Lordship,
the
here the
state is the আসল party.
Calcutta State Transport Corporation is the answering responding to Your Lordship. The state is not a party here.
7 July, my lord.
But they acted upon the report
State
of
is
this
not a
DIG.
party. No. 7 July's order, my lord. I find, my lord, Your Lordship wanted the presence of the DIG. But we are appearing pursuant to such order, my lord, will assist Your Lordship as and when.
No, because it is on the opinion of the DIG.
That it has been cancelled.
Yes.
I have to come back. This is a 2007 document, my lord, will allow some time and service of these copies, my lord.
No, first of all, you get yourself impleaded. Her CAN application, can one be disposed of?
Lordship, I have served the copy.
ঠিক আছে, can one dispose of copyটা
The learned advocate representing the petitioner.
The copy be served. Can one is not served as of now.
Representing the DIG, so DIG got the copy.
It is not.
Sir, now it's not required. You have appeared means what? She must have served you a copy. To have filed an application being CAN 1 of 2025 for addition of the DIG, is it?
The intelligence branch, West Bengal, Government of West Bengal.
DIG of police, you have set it.
Lordship, Deputy Inspector General. Intelligence branch, Government
Intelligence branch to be a party in compliance with order dated 7/7/2025. The department is directed to amend the cause title of the instant writ petition, impleading the DIG of police as respondent number 4.
Spot number 4.
The TAN application being won by 2025 is accordingly disposed of. The learned advocate Nanamta Diye has appeared to represent. So today I will not record your name. Let the cause title be amended first.
No, cannot. Party has.
These are complete, Your Lordship.
Okay. Next date be fixed on 6th of August. Let the
But in also, my lord, kindly grant me some time. Today I'm not praying. This is an old document, my lord. Either
in any way, first let the cause title be amended. Thereafter, you can see. In the meantime, madam, you can also give him
copy of the read petition be served
served
upon him.
upon.
amended copy.
Possibly again serve the copy.
Amended copy.
Next.
Question item number 53. All of us has come. I have got stuck in court number 12, 53. I couldn't come. Justice was called on. All the 3 petitioners.
You are for the FCI.
I'm for the FCI.
What is it?
It is an application filed by the writ petitioners, saying that they are asking for some benefit after promotion. We have said that, sir. We have said, my lord, you have filed a report. We have said that initially government has issued an order giving some promotion, giving some benefits. We have given them. Now thereafter, central government has said, withdrawn this and don't give them. We have for the pensioning authority is the government of India pensioning authority. We have written them in a report. We have said that they don't. What shall I do? Kindly take it. Recall the order. But the government kept mum. The 17 persons are getting those benefits. The petitioners are saying we want to get the same benefit. Therefore, reply has to be given by the government whether the first 17% should we get or not get. Or the last occasion, your lordship's direction was that the last chance to the government to file a report. Today was that I have filed a report.
Exception to the report.
Exception to the report. But they have not that. Now, my lord, as far as the FCI is concerned, I have filed report.
Now he says that the FCI people came and sought to meet him.
Lord, I don't know, Lord, government of India, but I forget about I have taken the responsibility of my people. I have filed my report. But the government has some instructions. Their councils are there. They will have to.
Sir, whether you are forgetting is a different issue. You have to understand what the situation is. Now, the representatives of FCI contacted Mr. Dasgupta.
I have heard, well, what has happened from the central government ministry has they have telephoned my officer to get contact with the central government officer to file a report immediately. That's the thing what has happened. Not more than that.
No, but then what value they will add?
That is their business, whether the business is allowed or not. Well,
so you are not understanding. The FCI belongs to you.
Belongs to me.
You have already submitted the report. The stance has to be taken by them, whether to consider the parity or not. Because 17 of other people have been receiving. Now they are saying that instead of the central government people, the FCI contacted them. So FCI can't give, they have already stated what they had to in the report, which had been filed by you.
The same officers cannot come and instruct me to take an action.
Your department.
Correct. No, I agreed to that. They have written to me day before yesterday.
FCI can't do anything to
They have written to me mail.
I have tell my officers not to go to him.
Yes.
Let them file a report.
No, I will bear on them. If they do,
write to the government officers.
Yes.
Don't ask my officer to go to them.
Yes.
Whatever it is, sir, your officers have already stated that as per the directions issued earlier, we are granting the benefit. The moment you said stop it, we have stopped.
This is my answer.
So now they have to say whether they are also entitled to similar benefits or not.
But that is not, let them file a report.
Certain lengths.
Sir, do you tell me which department? Then their unless and until their personal appearance is granted, they are sitting on it. Let them appear online.
Yes, Ministry of Food and Public Distribution, my lord.
Who are the concerned persons? Notice. to issue.
Malika, give me some time. The person who has sent the mail, I will give his name.
You come at 2 p.m., sir. Come at 2 p.m. Let them appear online and say.
Yes,
Unless and until they are doing this, they are not even acting. 2 p.m., sir.
May I appear online, my lord, at 2 p.m.?
Your presence is not required, sir. You can send one of your juniors. Next.
My lord, in item number 60, the advocate on record is appearing on his legs at
I'm sorry.
Jalpaiguri Circuit Bench. Kindly keeps the matter.
An order of my lord for personal appearance of the managing director of NBSTC. Now, one of the managing director is here. Now,
Yes,
the
sir.
personal appearance because of the fact that none appears for NBSTC on the day when the matter was called on. Then, my lord, an order was passed to the register of the department registry that to sub upon the NBSTC so that somebody may appear on the next day. Now, again on the next day, my lord, none appears. Now, my lord, naturally, my lord was kind enough to pass this order. Now, my lord, my humble submission, only thing, my lord, I may not satisfy your lordship with regard to any explanation. But the thing is this, that, my lord, that yes, that, my lord, the notice was served. And, my lord, at that point of time, my lord, there was another contempt proceeding. And that was on 1st July, it was listed.
So now
My
let's.
lord, may I tell, lordship, now, my lord, he tenders apology before your lordship.
Sir, one can
what
understand.
should be there, my lord, before your lordship on that day. Now, my lord, the lawyer missed the list, my lord, in any event. So far, the merits of the matter is concerned, matter regarding, my lord, non-payment of CAS benefit. According to the petitioner who retired from NBSTC, he was entitled to CAS benefit 10 years and then 20 years. But, my lord, in CS...
Sir, I believe you had appeared online the other day.
Yes.
So, sir, you
Other
please
matter.
be a bit vigilant on the acts of your staff. It's not the only case, sir. There are other cases pending where the learned advocates are saying that they are not receiving assistance from your department. So please ensure that I believe in the matter that you appeared online.
Yes.
So they could not trace the records for years together. But when there was an order of appearance, records could be traced, sir. So do you think it is good on behalf of both the parties to get into this kind of action? So please see that these things do not recur again. Yes, sir.
Now, my lord, so for the merits in the matter is concerned, my lord.
Sir, the pleadings are completed.
No. Sir, affidavit. But in any event, my lord, if it is not completed, I think, my lord, may I tell, my lord, yes. We have filed the report. I have gone through, and the report, it was stated that there was some, my lord, confusion over the payment. And, my lord, the letters, back-to-back 3 letters written to the state government, eventually, my lord, on the basis of the threadbare discussion with the state government finance department, now, my lord, which was told for a particular period from 2013 to 2016. After that, my lord, gradually it has been, my lord, started to issue regarding that CS benefit, whoever the retired. Now, these petitioners, my lord, the matter, also it has been taken up. Substantial progress has been done. And, my lord, I think on the very next day when we come back before your lordship,
there will be something favorable.
Yes, positive. Something positive. So kindly fix the matter any day, but after 15 days, so that, my lord, I can come with your lordship and say that the positive answer is.
My lord, only one thing, subject to your lordship's approval. My lord, I am appearing on behalf of respondent number 1 and 2, that is state respondents. My learned senior is appearing on behalf of NBSTC. Now, my lord, subject to your lordship's approval, the prayer made in the writ petition was filed in the year 2018 when the petitioner was in service. Now, my lord, in 2025, he is 62 years old, so already he is superannuated from service. I believe the prayers in the writ petition has to be amended in accordance with the subsequent developments, because he is asking 27 years of benefit as and when he was in service. Now he is superannuated. This is my duty to bring this
How many
to your lordship.
petitioners are there? Only one?
Only one writ petitioner.
So now the petitioner advocate is not present. You do all these things, you ask people to come. What is the actual objective, sir, so that the matter can proceed?
No, my lord, my lord, this is technicalities, my lord. This is my duty to point out before your lord.
Yes, sir.
My lord.
So, sir, you file your report on the next date. As you said, there has been a considerable development. You file a report?
Let us come back with the report and stating that whatever done. Yes. Form of affidavit.
Yes.
Then mother kindly give me 3 weeks.
Now, who is this respondent number 5, sir?
Respondent number 5 is kind.
Sir, managing director.
So, respondent number 5, in accordance, in compliance with order dated 8/4/2025, is present before the court. His personal appearance is noted and dispensed with. The learned advocate representing. Sir, you're representing respondent numbers 5 and
Respondent number
5. Five.
I am for 1 and 2.
I appear, my lord.
Okay. Respondent number 5
Sir, apni baki shobai.
is to file
1, 2,
a report in the form of an affidavit stating that
6, 7.
there is a considerable development in considering the issue raised by the petitioner in the petition
with regard to his entitlement to
concerning his entitlement in the CAS benefit. Next date be fixed on 23rd of September for filing the report in the form of an affidavit. The learned advocate representing the petitioner could not appear before this court, being engaged in another court as submitted by a junior lady advocate. You have written the name of your senior who is appearing somewhere else.
My name.
Next.
Appearing on behalf of the petitioner. Lordship, the petitioner is challenging the action of the respondent number 2 in recovering the gratuity which was paid to him at the time of cessation of their employment. Now, Lordship, on the last occasion, Lordship, the respondent number 2 was directed to file a report, Lordship.
Yes, who is appearing for respondent number 2?
Mojumdar, Lordship.
I am for Union of India only, my lord.
No copy has yet been served.
No, but they have. They had to file the statement of accounts.
Yes.
This is at Retired Employees Association.
Lordship, Retired Employees Association challenging the recovery of gratuity after its payment at the time of cessation of employment and also non-payment of pension at the revised rates. Twofold prayers are there in the petition. Lordship, initially, Lordship, the petition was dismissed since Lordship, there was a coordinate bench judgment holding that the respondent number 2 is not an authority within the meaning of Article 12 of the Constitution of India. Matter carried up in appeal, Lordship. The appellate court also affirmed the view of.
So he's your junior. You ask him to find out, Mr. Mojumdar. You wait for some time. Next.
I'm trying to bring.
For the petitioner's
publicly put forward one of 2019 Lordship. My supplementary, I am filing my supplementary affidavit and affidavit of service to that effect.
It is now.
What was this supplementary affidavit for?
Application can file for substituting by General Secretary of the Union died on 27 January 2025. Thereafter, your Lordship granted us leave to file an application for substitution.
How many are there in total?
Petitioner. I'm representing only Union Lordship.
Lordship, I am also representing the union. There is a dispute within the unions.
There is a checkered history of this matter. Checkered history of matter, Lordship. And from 1998, this union is fighting this matter. In the year of 1998.
How many petitioners are there?
I am for 953. I represent the Eastern Railway Contractors Workers Union, and he will undoubtedly say the same for his matter.
Yes. My writ was filed prior to them. I am representing the union.
So you only know the numbers whom you are.
Yes, because our contention is supposedly different from what they will submit.
You are in which petition?
953. Item 95. This thing 953. Item 67.
There are 3 petitioners there.
Yes.
In 953, how many petitioners are there? Record ta dekhun ta.
Two petitioners.
2 petitioners.
Yes, the president and the union.
I'm asking you, how many are there in the union? How many petitioners constitute the union?
4,000 above, Your Lordship.
4,000 above have come to file their writ petition in individual capacity.
On behalf of the president, we have filed the writ.
So in your petition, union is represented by whom?
By the president, Mr. Nityanand Jha.
Where is he? Is he there?
No, he's not there.
So, because I find a number of people standing here. Now, in your writ petition, there are 2, the union and the union being represented by the president.
Yes.
Right. So what about this one? 24331 of 2019? 24331 of 19?
4,000 members in the union.
Are you the advocate on record? Then who is the advocate on record? Who is your senior?
Out of session. There are 3 petitioners in W2431.
Now let me dismiss that the other writ petition also. Because he never appears.
He appeared on the last 2 days. Because he's out of session today.
On the earlier occasion also he did not appear.
He was also out of session on that day. Pardon myself, he was outside on that day too. Out of session.
In this matter, my lord.
So will you please help me?
Yes, my lord. In this.
So they have given you the copy of this scan application?
Yes, my lord.
Just check and then tell me, because they are in no way connected with whatever it is. He has just come to file this supplementary affidavit.
24331 is possibly the first petition. 24331, right?
And what about this 9710? Who is appearing in 9710?
9710 is in somebody else's name. but the first two, 66 and 67, both are in the name of the same union.
One
Eastern-
Subroto Bhattacharya appeared.
I am for the applicants. I am for the applicants in 9710.
So who are the main
Kahan na.
persons in 9710?
Tridip Sarkar was the first applicant, along with the 130 petitioners. 130 petitioners. Then the instant applicant for which I am appearing, actually the instant applicant dissatisfied with their activity. Then they filed an application and requested to the learned advocate to get some brief and no objection, but not submitted, but not given for which the applicants has filed and applicant shelter before the lordship. Actually, what happened? Actually, I am
What is this supplementary affidavit they are filing on petitioner?
Because they did not submit the death certificate on the last day with their substitution application.
Certificate with the page, lordship.
My lord, your lordship is please allow me in gist actually what happened, my lord. Why the said three petitioners? Why the 5,500?
Sir, first of all, how many they have come up in 24331? Now, petitioner applicant number 2. Was this person representing the union?
Yes.
Yes, madam.
President and secretary. President and secretary. Secretary expired, my lord. That is the
Now who had signed the wakalatnama?
Lordship.
Earlier occasion file. Earlier occasion file.
কে ফাইল করেছিল? আরে
Sujita.
May I, Lordship, in the who has filed on behalf of the union was carried on 27th January 2025.
who?
There are
Sujit. Three.
And also Deepak.
Yeah. Please let me cover thereafter you can. The petitioner number 2 was died on 27th January 2025. Thereafter, the matter came up on 7th March. Your lordship granted us leave to file the wakalatnama and the substitution application recording the date of the petitioner number 2 and who has represented the union. That's the petitioner number 1 in 24331. Thereafter, to that effect, we have filed an application that is Can 5 recording the date of the petitioner number 2 in 24331 and the representative of the union. However, lordship, the date certificate was not there. Your lordship was kind enough to grant us further leave to file a supplementary affidavit with annexing the date certificate of the petitioner number 2 and representative of the union. We have filed our supplementary affidavit to that effect, lordship.
So who will be substituting?
Substituted will be the petitioner number, name of the petitioner number 2 may be, your lordship, may be deleted, and petitioner number 1 in 24331 may be represented by Sri Ranjit Kaduma.
Where is that application? Where have you stated? Where have you stated that?
তোমার সাবস্টিটিউশন অ্যাপ্লিকেশনটা
দীপক কুমার বোধ আছে সেক্রেটারিতে আছে
You want the name to be expunged on account of death.
Yes, under order 22 rule 10 of CPC. Prayer A, lordship of my.
Then what? Then who is going to represent the union?
Ranjit Kaduma.
Where is that? Where is that application? Where is that application?
অ্যাপ্লিকেন্টের নাম কোথায়?
আরে প্রেসিডেন্ট তো আছে এখানে প্রেসিডেন্ট রিপ্রেজেন্ট করবে
Paragraph number 4, lordship. Page number 6, can application, paragraph number 4.
This Ranjit Kadma is present in court. Is he there in court?
No, lordship. I'm told he's not.
Chanchal,
May I be permitted to submit before actually what happened, my in
now we are not going to what happened.
No,
Let the technicalities get over.
it is true, it is true. On for different days, my
Wait, sir.
এর মনে হয় শেষ হবে না তুমি বাই স্টেপ ওগুলো করিয়ে দাও না কিছু করবে না আর করবে না ওটা তো ডিলে করা ধান রাখা ডিলে করে কিছুই হবে
এ কি আদৌ অ্যাডভোকেট অন রেকর্ড কিনা কে এর নামটা আছে? What is your name?
Anushka Short.
The learned advocate representing the petitioners in WPA number 24331 bracketed W of 2019 has filed an application being 5 of 2025, which inter alia stated that the petitioner number 2, namely Shujit Kumar Das. What do you mean by expired on or about January 27, 2025?
There may be grammatical error. Okay. There may be grammatical error.
So you smile and get away. There.
बहुत बार क्या रहा
27.
On January 27, 2025. A supplementary affidavit dated affirmed on 20th May 2025 had been filed by the learned advocate representing the petitioner in the instant writ petition or opore number ta diye debe, annexing a copy of the death certificate of the petitioner number 2. It was further submitted that one Ronjit Kodma had been presently entrusted to carry on the duties and responsibilities of the General Secretary, Eastern Railway Contractors Workers Union, who had affirmed the CAN application being 5 of 2025. The department is directed to delete the name of petitioner number 2 and substitute the name of the applicant, Ronjit Kodma, in place of petitioner number 2 and amend the cause title of the writ petition accordingly. The learned advocate representing the petitioners in WP 953 of 2022 is present. You now tell me, sir, you are the applicant in 9710. So what do you want?
Actually, my lord, the writ petition in this writ petition, 130 writ petition was there. There, my lord, some petitioners now at the applicant and praying for leave to file to submit their individually, my lord.
130 will submit individually.
130 total writ petitioners. Here, my lord, 52 are.
Now I remember, I had
Yes,
asked you.
My respectful submission.
You have not done that. I had asked you to prepare a list. out of 130.
Application is there, madam. Not list is necessary.
I had asked you to prepare a list.
No, in the application, this is Mary. In the application, the petitioners are there. That is the
But you said out of them, somebody has been left out or some were unwilling,
Yes,
did
but
not come. This is what you told.
The applicants here in kindly see, my lord. The applicants here and total applicants, my lord. Total applicants, my lord, 25. Serially, it has been listed. Written, my lord. Serially.
Then what is it? Why are you mentioning 130, then 52,
130,
then 25?
No, 130 total lead petitioners. In the lead petition, 25 applicants here in, they have filed application in connection with the said lead petition. For submitting individually, my lord. Actually, what happened? I am submitting, my lord. Actually, what kindly consider about 2 minutes, my lord. 2-3 lead petitions. So many the contractual lawyers. They are saying for praying for regularization in several lead petitions. Actually, what happened, my lord? The Sujit Kumar Rai, who is the secretary in the who has expired, my lord. When they have got the other contractual labor, there is a huge corruption.
So we are not going into the merits.
Yes, it is true.
You
it is true.
first tell me.
My lord, it is true. My lord, kindly allow 1 minute, my lord.
Sir, I will not listen to you now in this aspect. First, you clear out the numbers.
Number 25. In the can, my lord, can you see? Can number 1 in connection with the 97.
number.
এই এটা রেকর্ডটা কোথায় 9710
আরে এখানে তো আছে তা তো না
খুব সিম্পল কথাকে কমপ্লিকেট করো না
and praying is same regularization. They are also the contractual, but several lead petitions filed.
So don't you understand? I'm telling you that I will not go into the merits. First of all, clear out the number of the petitioners.
Number of the total lead petition in this one
who has filed this? You have filed this can 1 of 2024.
Yes, ma'am.
Now there are 130 petitioners.
Yes.
Last one is Nikhil Day.
Last one is Nikhil Day. Yes.
Nikhil Day. Now why have you filed this can application for what? Now these 130 petitioners, they have been represented by a single person.
No.
Or individually?
Individually, my lord, I have.
What is the wakalatnama?
Oh, no, filed in the.
You have received to represent the wakalatnama.
Yes, my
on behalf of 130?
No, 25.
That's exactly what I'm asking you. You are for 25.
Yes, I have got the wakalatnama.
You have got the wakalatnama for 25.
Yes.
What about the others?
Others, I cannot say. The others petitioners knows it very well. That is advocate and court advocate he knows it very well. The first.
Devopriya Mondal.
Huh?
Devopriya Mondal.
Devopriya Mondal.
Yes, I have requested, my lord, the petitioners, instant petitioners requested to hand over the brief, file an application, no objection, but not given, my lord. Then finding no other alternative, they have filed this application, my lord, with the Bhagavad.
So now what is your contention in this can application?
Condition application, my lord, kindly allow the petition by submitting their submission, my lord, individually.
So today your writ petition will be allowed?
No, I am not saying so, my lord.
Then?
Only this writ petition will be allowed, and my lord, others will be pending. I am not saying so. My submission is that if your lordship is pleased to allow.
Without hearing, I will allow your writ petition today.
It is not possible. While actually, my lord, kindly consider that their age will be over. Already age has been over. My lord Sujit, most probably he expired, my lord. Just to kill the time. Just to kill the time for which, my lord, lingering day to day, year to year.
Now, in paragraph 4, what have you written? Your applicants state they have come to know that hardly about 65 genuine persons.
Yes, sir, can. And these.
Now you have, in the prayer portion, you have written.
Yes, ma'am.
Now, these applicants to move separately in connection and further be pleased to direct or liberty is given to the said applicants to submit the single representation.
Before the authority concerned, my lord. That will be considered.
Johnson, you are appearing on behalf of the applicants here. That is to be noted.
Yes.
Rest of the parties you are not concerned with.
Yes, but they are not. Yes, yes.
Right? And none appear to represent those 105
Yes.
petitioners. Right? Acha. The learned advocate representing the applicants number 1 to 25 in CAN application 1 by 2024 intends to represent them in WPA 24331 of 2019, and the same is allowed. Now, in the Wakalatnama, the 25 names are there.
Yes. Yes.
Wakalatnama, you have filed that,
Yes.
I have understood.
Yes,
Have
yes.
the
25.
25 names are there.
Yeah, madam.
They,
petitioner number.
where did you file? In the department? You have filed in the
And
department?
the application most probably.
আছে এখানে? Did it? Yes. None appear to represent the remaining 105 petitioners in writ petition being number 24331 of 2019.
No, 9710.
Sorry, 9710 of 2020. Now, who is appearing for the respondents? Sir, you in all the matters. No, ওটা 997
স্ট্যাম্প
ওটা 9710 of 2020 হবে।
না ওই একটা লোকের স্ট্যাম্প
I am also appearing with Mr. Indrajit Dasgupta.
Yes, post.
যে স্ট্যাম্প যেটা দিতে হয় এতে রিটে তো ইন্ডিভিজুয়াল
No, the pleadings are completed.
No, Your Lordship, we have not begun. We have not begun yet.
You have,
অ্যাফিডেভিট কোনটাতে হয়েছে অ্যাফিডেভিট
so you have received the copy of the writ petitions?
yes मतलब affidavit is possibly completed in
4331 of 2009. In my petition, affidavit,
So when I asked you, why didn't you say? ওটা চেক করতে হবে, না করে বলা যাবে না। Have you, sir, did you file affidavit in reply?
yes, sir. Affidavit in reply has been.
এই 24 কত বললো? না 3310 নাকি একটা আছে।
item number 66 তো?
133
66 তো
66, yes.
আচ্ছা তাহলে ওটাতে লিখে
এখানে অনেক জ্ঞানেরও পজিশন আছে।
learned advocate representing the
এরা পজিশন
respondent
দেখে নেবেন। জ্ঞানগুলোরও পজিশন হয়।
ওই
953
953 of
2022.
2022 is to file the affidavit in opposition by 22nd of August, reply if any, to be filed by the learned advocate representing the petitioner in writ petition number 953 of 2022 by 15th of September. A copy of the affidavit in opposition is to be served upon the learned advocate representing the petitioner in WP A 953 of 2022 in advance. আচ্ছা ওটাই আছে অপোজিশন আর রিপ্লাই আছে দুটোতেই ওই 24331
Opposition নেই opposition নেই
So you come at 2 p.m. Let them check in the meantime. Next date be fixed on 16th of September. না ওটা তো থাক 959533 তার সাথে ওইটা তোমার না 9710 তো আজকে কেউ আসেনি না নেক্সট ডেটে যদি কেউ আসে ভালো না হলে পরে
No, I'll be
Next.
filing affidavit only in 953 man.
Yes, because sir, the others are not there. I've given them a chance. If they come on the next date, it's okay. Otherwise, then you can file. Next.
Obliged.
I appear for the
I'm for the respondent number 326.
Yes, sir. Your affidavit in opposition.
My lord, that is all filed in the department. I suppose, my lord, it has tagged with the record, my lord. On the earlier,
My reply is ready. I have
You
already
received the copy of the opposition?
Yes.
The affidavit of service, reply, opposition paper. When did you file it in the department, sir?
my lord, it was filed on 23rd of July 2024. And my lord, on the
Lord
last
Advocate
date, my lord, I pursued the matter to the department and it has been brought here.
May I play his affidavit I can place before your lordship.
No, but he says he has filed in the department, sir.
Maybe my lord will rely on, he has served me a copy of that same affidavit.
Fair enough. But then if he has filed it in the department, it should be on record, sir.
Yes.
As he is saying, he has filed
Only
it.
one thing that I submit that if it is adjourned today for this ground, my lord, kindly hear me. I am for the petitioner. Kindly.
It's not getting adjourned, sir.
Okay,
It's
my lord,
just
my lord, then oblige.
the learned
Page.
advocate representing the respondent number 326 has filed the affidavit in opposition. Let the same be kept on record. Affidavit in reply to the same has been filed by the learned advocate representing the petitioner. Let the same be kept on record. Yes, sir, what it is?
Yes, my lord, my writ petition was summarily dismissed on the ground of territorial jurisdiction. Before I state the fact, I state two things. My lord, against which I preferred an appeal before the Honorable Division Bench. Division Bench remanded the matter, keeping all points open. That is why today I am present before your lordship. My lord, the petitioner, my lord, now I tell the facts in nutshell. My lord, petitioner joined Export Inspection Council on 9th of September 1969 in Kolkata. Lordships, kindly come to page 21 of the writ petition. That is the joining letter. Your lordship will find that from the joining letter, it would transfer that I
But
joined.
that was in the year 1969.
Yes, this is for a different context. I am coming before lordship for transferring from CPF scheme to GPF scheme. And the Supreme Court recently said that pension is a continuing cause of action. I know that they will take the point of delay. My lord, in 20 from that 21 page 21 joining report, your lordships kindly come that I joined the Office of Export Inspection Council at Kolkata. My lord, Export Inspection Council, as your lordship knows, is a central government organization and a transferable job. I was posted in various stations and I lastly retired when at page 23, if your lordships come, that director in charge of Export Inspection Agency Cochin with temporary posting at Kolkata. I was sanctioned an amount after retirement, amount of rupees 13,65,210 towards CPF. At that relevant point of time, there is no GPF scheme. So I have to opt it for that CPF scheme. And later on, my lord, government had issued a circular that who has opted for CPF scheme and there was no GPF scheme, they can use an exercise option to convert to GPF scheme. My lord, I was retired. I stationed in Calcutta. I didn't know that that scheme came. My lord, later on when I came to know, my lord, I exercised an option. My lord, during my service also, my lord, if you lordships kindly come to page number, my lord, in affidavit in opposition, they have admitted that fact. I'll place that on also. My lord, now the problem is, now they decline to give me the benefit of GPF scheme. My lord, I am a septuagenarian lady with various ailments, heart and other diseases. My lord, if some extra money I'll be given, I am ready to refund the amount which I have received. But the GPF amount will be much higher. That is my point. Now, the question is, so far the territorial jurisdiction is concerned, when the writ petition was rejected, that I retired from Cochin, and on that ground, that I should have filed a writ in Kerala High Court. My lord, I will place a decision. My lord, Nawal Kishore Sharma, আমারটা ফ্ল্যাগ করা আছে, এটাতে আছে বুঝে জজ সাহেবের কপিটা দিন, জজ সাহেবের কপি দিন। My lord, the head note says that the jurisdiction of High Court, invocation of against authority person residing outside territorial jurisdiction of High Court, cause of action, if wholly or partly arising within the territorial jurisdiction of High Court, determination of parameters thereof. Cause of action has been defined. My lord, lordship kindly come to paragraph 2 of that judgment. These are the facts. It is the case of the appellant that it was found medically fit in the medical test conducted by the Marine Medical Services in February 2009, and thereafter on 29 September 2009, an agreement known as the Article of Agreement for Employment of Seafarers was executed for the appellant offshore duty on 18/6/2010, when the appellant reported sickness, that is cough, abdominal pain, swelling in leg and difficulty in breathing. He was sent for medical treatment ashore at Adani, Mundra Port. The medical officer ashore advised him for admission in the hospital, and accordingly he was signed off for further medical treatment. Thereafter he was considered permanently unfit for sea service due to dilated cardiomyopathy as per certificate dated so and so issued by the corporation's assistant medical officer. Consequently, the shipping department of the government of India, Mumbai, issued order dated so and so cancelling the registration of the appellant as a seaman. It is contended by the appellant that after he settled at his native place Gaya, Bihar, he sent several letters, representations from there to the respondent for his financial claims as per the statutory provisions and terms of the contract. On the disability compensation claim, respondent number 2, the corporation communicated via letter dated so and so that since the appellant was declared unfit for sea service due to heart problem, he will be entitled to receive severance compensation of rupees so and so, which was although offered but not accepted by the appellant. It was also informed that he is not entitled to receive disability compensation, which becomes payable only in case of seaman becomes so and so. By filing writ petition, the appellant approached Patna High Court under Article 226 of the Constitution for grant of various reliefs, including 100% disability compensation and pecuniary damages. However, at the time of hearing, the respondent raised the question of maintainability of the writ petition on the ground that no cause of action or even a fraction of cause of action arose within the territorial jurisdiction of Patna High Court and contended that appellant was appointed by the corporation on the post of seaman for offshore services and discharge his duty outside the territory of state of Bihar. It is the case of the respondent that the order declaring appellant permanently unfit as well as the letterhead dated so and so was passed by an authority of respondent corporation in Mumbai. Per contra, it is the case of the appellant that he is a permanent resident of Bihar and he is asserted his right in the state of Bihar and all compensation with respect to the rejection, all communications with respect to the rejection of
Sir,
the
but then you come to page 341.
341.
I mean, the impugned order therefore cannot be sustained in the peculiar facts and circumstances of the case. Sir, I believe this has been under Article 142.
My lord, Noel Kishore sir.
Because there has been a detailed discussion, sir. You can.
Yes, this judgment was further relied upon by other decisions where it is said that even if a person join in an office in some state and retired from other state, he is entitled to file a writ petition in the state where he belongs.
That would have been more appropriate than this one, sir.
Yes. I showed this judgment because that was the first judgment.
That would have been more appropriate than this.
This is, my lord, reported in 2020 10 SCC page 766. I rely on paragraph 4 first. This is Shanti Devi's judgment.
Volume number.
10.
Yes, your case has been mentioned in paragraph 32.
Yes. Paragraph 24.
32, 33, 34 suffices, I mean, it suffice your issue.
It starts from paragraph 25 and 34, 30. Nawal Kishore has been relied upon, and later on it says that allow the appeal. Well, this is the ground on which I stand for the objection regarding territorial jurisdiction.
It's the territorial issue concern.
Now, the second point is that
Sir, in any case, it will take some time, I think.
yes,
We can't finish it off today, so I'll give you a next date because there are other matters also.
my lord.
I mean, from second half, the
My lord, if your lordship permit me, I'll prepare a 2-page short note.
Yes. Heard the submission of learned advocates representing the petitioner as well as the respondents. Next date be fixed on 11th of September.
11th of September. My lord, much obliged.
Next.
Item number 81, Lordship. In this matter, Senior Advocate Mr. Somrat Sen is appearing on behalf of the petitioner, Lordship. He could not appear today due to some personal difficulty. I am praying for 1 week time for filing for affidavit in reply, Lordship.
Respondent bank. My lord, they were supposed to file the affidavit in reply.
Was
1 week time for
Chonchon. It was, they had to file the affidavit in reply.
Probably to the, it is the last chance, my lord.
Yes.
Bow down, Lordship. Praying for 1 week extension, Lordship.
They were given sufficient time.
Lordship, I'm praying for 1 week extension, Lordship.
Are you the advocate on record?
No, Lordship.
Achha. Who is the advocate on record?
Chiranjeev Sinha, Lordship.
And who are you, madam?
I'm led by Mr. Somrat Sen, Senior Advocate, Lordship.
And the advocate on record is not there. The advocate on record representing the petitioner did not file the affidavit in reply in compliance with the earlier orders dated
11th July, my lord.
Huh?
11th July. Last order.
16th of May to 2025 and 11th of July 2025 till date. The learned advocate representing the respondent bank is present. The register administration LOM is to serve notice upon the petitioner to the and file a compliance report intimating the next date of hearing. Next date be fixed on the earlier occasions also no one appeared.
No,
They
Lordship.
just
Somrat
came and
appeared, Lordship. Senior Advocate Mr. Somrat Sen is appeared earlier occasion.
one Miss Porna Roy Chaudhary and one Miss Payal Ghosh had appeared for the
Lordship,
petition
I am
on
Payal
the
Ghosh.
earlier occasion. Achha. Which is the place for the Badwan. Next date we fixed on 14th of August. Sir, on that no further time is to be granted for filing affidavit in reply. Today it was fixed as last chance. That too after 2.5 months time being given. Next. Fast. Yes, sir.
Sorry, Lords, the first call I could not. But as for your Lordship direction, I have served the notice upon the learned advocate, senior advocate who is appearing for the Union of India.
Now tell me.
Is the affidavit of service?
Affidavit of service filed by the learned advocate representing the petitioner be kept on record. The learned advocate representing, sir, you are representing Union of India.
1 to 4 Union of India.
Respondent number 1 to 4 is present.
So this is my affidavit in reply, Lordship.
I'm for the state. I'm led by Mr. Joyanta Shankar.
I believe he was there in the first session.
Yes.
The learned advocate representing the state is present. Affidavit of in reply filed by the learned advocate representing the petitioner be kept on record. Now the pleadings are completed.
Yes.
Next.
My lord.
Kindly see whether the opposition is on record, because last occasion your Lordships.
Opposition ta recorded.
Copy of the opposition is with me because it is 2012 matter. So previously there was another advocate who was representing the Union of India. Now, my lord, it has been allotted to me.
Where is your senior?
Opposition was served, Your Lordship. On the last occasion, in 2023, an order was passed so that we be served. A copy has been served upon us. I do not have the...
Who is to file the affidavit in opposition? Who will file the affidavit in opposition?
Lordship.
Yeah.
The Union of
State was not directed.
No, Lordship.
Then what about you, sir?
The state is not a...
No, sir. If there was a direction, dekhi record ta din na.
Opposition.
Opposition has been...
This is the problem.
Opposition has been filed, I find from my record. But I don't know
opposition
whether...
has been served upon the learned advocate for the petitioner.
Yes.
But Lordship, opposition, whether in record, I don't know, because lawyers have been changed.
No, this is an order of 19th December 2023. I saw this and thereafter it says affidavit in reply filed on behalf of the petitioner to the affidavit in opposition filed on behalf of Union of India is taken on record.
Yes.
Tale kothay?
Definitely there...
Did you file in the department?
No, this is my affidavit in reply.
I'm not asking you.
Okay. No, I have not filed anything before in the department.
Where did you file then, sir?
The earlier advocate who was appointed for in this matter, my lord, he may have filed it in the department.
Check korun. Because there is an order to this.
Otherwise,
so let the affidavit in reply be kept with the record.
Let the matter be fixed under the heading to be mentioned on 30th of July. In the meantime, let them find out whether they have filed in the department or not, because the order specifically mentioned about filing of it.
Yes. So, my lord, can it be 1st of August, my lord? 30th?
30th? You need not be there if you are not. It's only for the department to state whether the opposition is on record or not. You can ask any one of your juniors to be there. Next.
Lordship, I appear on behalf of the
Yes, sir. Where is your report? It was to be filed today.
Defaulter in that case not kindly.
It was fixed as last chance, sir. You had been given sufficient time. Yes,
Lord, I mean, a lot of predicament may not be.
in this matter, I think in other matter. Yes, earlier also.
The Lordship was pleased to call for a report on one occasion.
No.
The annuity calculation and the
No,
quantum
this
of.
was on the earlier occasion for the Union of India. You're not representing Union of India. Yes, tell me.
Kindly
So
explain
if if it is given for first chance, you will
expensive.
you will seek an extension. So nowadays from next time onwards, I'll
Peremptory.
not peremptory as last chance only. No, if it is not as last chance, you will seek.
But fast can never be last.
Sir, last date was 23rd.
No, I understand, but I found out from him rather, instead of my learned advocate on record who has suffered a ligament injury and staying at home.
How long will you take as last chance?
Fortnight.
Ashwin. So your advocate on record suffered ligament injury. That is why you did not come, and I had to call you.
No. That's I also came to know from him only.
Lordship, the advocate on record is not receiving the notices, Lordship, for a long time, Lordship. He says he is not in the matter.
I face this in each and every matter, nearly each and every matter.
But I was not present at the time of first call. Not that's kind. I tender my apology, but that's my habitual default.
Do you think it's a?
That's not because of any.
I think it's a matter of right.
Not a matter. It's my habitual default.
The learned advocate representing the petitioner and respondent number 1 is there.
Lordship, he was there.
Respondent number 1 are present on the prayer of learned advocate representing the respondent number 2 to comply the order dated 23rd of April 2025. Let the matter be fixed on 18th of August as last chance, sir.
It may be served earlier, Lordship, so that we can cover.
You serve it to him, sir, in advance.
Lordship, declare.
Invariably, they will prepare it on either I gave the date on 18th. They will prepare it on 17th or 16th. So in any case, you will receive it on 18th. Arache, pass over. 2 p.m., sir.
You're taking a forward.
Yes. Provided all of you are here.
Item number 1, 3, 4, and 5, my lord. Mr. Devdatta Basu is appearing in this matter, my lord.
And for the
He has
respondent.
not come today, my lord, due to his wife's illness, my lord. She has taken to CMRI, my lord, for immediate medical checkup and treatment, my lord.
And for the respondents, my lord.
After tomorrow, my lord, any day fixed, kindly, my lord. Tomorrow is also deployed. 3, 4, and 5, my lord.
1, 2, 4, 5.
Madam, Junior, no, my lord, Mr. Basu is on record, my lord. See,
Basu,
yes.
নামটা দিয়ে দেবেন, the learned advocate,
My lord, I am grateful.
that the learned advocate, Mr. Devdatta Basu, could not attend court due to his wife's ailments and seeks for an accommodation. Next date be fixed on 6th of August.
My lord, I am grateful.
Much obliged.
I'm obliged, my lordship.
Number 2.
Item number 2, my lord, I appear for the petitioner. Lord, I was supposed to file a supplementary affidavit, which is ready, my lord. I'll file it now. I had served it, my lord.
Supplementary? When did you file? Today?
No, my lord, I'll file it now. I will. My lord, this is, my lord, may I?
No, you end your conversation.
I'm sorry, there was a confusion with regard to on whom the service has been made. But the service has been.
No, where is the supplementary affidavit?
My lord, it is coming. It's on its way. My lord, may I indicate why the supplementary affidavit is being filed? It's on its way. My lord, I apologize, my lord, for this. But why the supplementary affidavit is being taken out is because during the pendency of the writ petition, an order has been passed by the High Court administration, which, my lord, prejudices my right, and which is also covered, my lord, by my writ petition with the prayers made in the writ petition. Only to bring on record the order which has been subsequently passed by the High Court administration refusing the prayers made by the writ petitioner. My lord, this is the. May I?
আসুন।
না ছিল কি করে বলবো?
You on the earlier occasion had declined to file the affidavit in reply, right?
The affidavit in reply to the amendment application. But I'll tell my lord, after the writ petition was filed, my lord, this order was passed, which I sought to bring on record by way of an application for amendment. In that amendment application, my learned senior friend used an affidavit. My lord, that affidavit clearly repeated the contents of the order itself. My lord, thereafter, it was your lordship's observation that instead of an amendment application, I may be allowed to bring on record the supplementary affidavit, which your lordship will decide whether it goes beyond the scope of the writ petition or not. My learned senior friend took the point that it goes beyond the writ petition, so this cannot be amended. It would change it would alter the nature and character of the writ petition itself. That is why this supplementary act.
Last date was 16th of May 2025.
My lord.
Right?
Yes.
Today you were supposed to file
the supplementary affidavit. Yes.
So you were not aware.
I'm sorry, my lord.
You were not aware of the next date.
No, I was, my lord. Even my lord,
So just look at your conduct.
But I do not know, my lord, what to say. But it is with the
And
I really could not give
an amendment application after 7 years from the date of filing of the writ petition.
It's here.
When Millard affidavits have been exchanged on the writ petition, Millard,
see what they have filed and.
I am not favored with a copy. That I a copy to the
Yes, may I file it? I apologize, my lord.
Supplementary affidavit filed by the learned advocate representing the petitioner in compliance with order dated 16th of May 2025 be kept on record. A copy of the same has been served upon the learned advocate representing the respondent number 1.
The High Court administration, Millard. It's respondent numbers, Millard. I just indicate it's 1, 2, and 3.
1, 2, and 3.
Respondent number 1, 2, and 3. Now you will seek
Yes, my lord.
Yes.
My lord, I need to place it before the honorable committee. My lord, if the honorable committee is of the opinion that my lord we should use an affidavit, my lord, I have to use an affidavit.
My lord,
Kindly
it is
grant me,
only-
my lord,
but it
4
is-
weeks time, my lord, to.
Right, it's
Next
only to
date
bring on
we
record their
fixed
own
on,
order. But it is nothing else. I have not made any allegation. On the supplementary, I have not made any allegation. It's only to bring on record the order passed by
4th of September
in the meantime.
for seeking clarification by the learned advocate representing the respondent number 1, 2, and 3 from the concerned authorities.
Would it be my lord's kind pleasure, my lord, also to grant me a liberty in case, my lord, I wish, my lord, to file an
Affidavit in reply
if at
to
all.
the
my lord.
aforesaid supplementary affidavit, if any, to be filed on the next date of hearing.
So grateful to your lordship.
But if shorter directions could be given, then we would exchange our affidavit
The
and come
amendment
back.
application came after 7 years.
No, that's
Next,
all right, my lord.
appellate side. হয়ে গেছে তো?
Grateful to your lordship.
আমারটাই প্রথম। এই 2 p.m. Three এখন না, পরের গুলো আগে দেখো। গ্রুপ 6 আগে। না না হয়ে গেছে। So you generally appear for the railways, don't you?
Union of India, Railways.
Railways you appear. So why don't you appear in, I mean, in this matter? You can take down the number and get yourself appointed.
Along with me, then my lord, some junior is to be given.
So that is up to you, whether you will engage one junior or whatever it is. But
I cannot appear.
sir, I'm asking you to get yourself represented. You take down the number, or else you need directions.
Yes, in other matter, my lord, your lordship, pass direction, my lord.
Other side কোথায় গেল?
Mrs. Seema Ghosh is in another court, my lord. She has instructed me to be present on her behalf.
The learned advocate ওনার নামটা, who generally represents railways, is requested to represent the same in the instant appeal. Let his appointment be regularized. Sir, that I can't do. That
My
you
lord,
take up with your authorities.
My lord, may I exchange the paper book, my lord?
Paper book is there.
Yes, my lord. Paper book I am filing, my lord.
You file the paper book. Paper book filed by the learned advocate representing the appellant claimant be kept on record. Next date be fixed on 9th of September.
9th of September.
Next.
এটা নিন, কপি নিন।
16.
Lordship, I appear for the respondent. Lordship, on the previous occasion, there was a direction for producing the records as well as filing of a written notes of argument. Lordship, the records are before you. I have brought the records, but Lordship, I'll need some time to file the written notes.
No, where is the record?
Lordship.
Ashun. The learned advocate representing the petitioner is present. The learned advocate representing the respondent, Union of India, has filed the case record of records pertaining to the disciplinary proceedings instituted against the petitioner in compliance with order dated 22/4/2025. The court clerk is directed to keep the said case record in safe custody. On the prayer of learned advocate representing the respondent, Union of India, to file the written notes, next date be fixed on 10th of September.
Dada.
53 is
Fifty-three. This is the FCI matter, my lord.
yes. Now what happened?
My lord, I only know, my lord, that the secretary of Ministry of Food has been made a party, but directions were passed by the director FC3, Department of Food and Public Distribution.
Sir, upon whom the notice needs to be served as far as you are concerned. You leave aside the FCI now.
Director FC3, Department of Food and Public Distribution.
But they have already submitted their report.
No. Department of Food and Public. That is Food Corporation of India. That's a corporate body.
So it is respondent number?
He is not a respondent here, man. Because the respondent is the secretary. Secretary, Mallar.
So then, sir, you have to.
Then, Mallar, kindly adjourn the matter and give me some time to sort it out, Mallar. Because secretary hardly gets involved in.
No, since the department that you're naming is not a party, direction cannot be issued upon them. So you got sufficient time, sir?
Yes, Mallar. Kindly give me one more. If they do not, Mallar, the issue is whether Food Corporation of India is the central government passed an order, made it applicable, then withdrew it. What they are saying is that
they are saying that we abide by whatever the central government says.
My lord.
Once they have issued the order to pay, they have paid.
Language. After going through the language of
once they have precluded them, they stopped paying.
Yes. Well, the report has cast the onus on this.
Anyway, sir.
Language, kindly. Hence, the onus in respect of implementation. This is the objective part, my lord. The onus of implementation of the government decision in instant matter lies with PN accounts of the Ministry of Corporate Affairs, Food and Risk. This is actually not a correct. We have to object to this, my lord. Onus is not on us. You have implemented. You can say that we are bound by the directives issued. Onus for payment is not on the ministry.
No, they must be saying that since they are funded by the ministry.
That is not their case. Then things. That is why I am objecting to this particular line. They are not funded, my lord.
They are not funded.
Not on the basis of, possibly not on the basis of salary. Some help is always
what
given.
What is their source of function then?
My lord, the Food Corporation.
Yes.
It's
under the central government.
Food Corporation is a corporation. It has to generate its own funds, my lord.
So that
and it gets grants. Subsidiary. It is a subsidiary, my lord, not a subsidiary. Food Corporation of India is in itself a corporation having a legal entity. It is not a department of the Union of India. It may be controlled by the government of India.
So you mean to say that they generate their own fund?
They are supposed to. They get budgetary support, not in respect of particular salaries.
Sir,
or
you also get yourself clarified. It
yes,
seems that you are also not very clear.
Yes, madam.
I give you 4 weeks time, sir. By that.
Yes, miss.
On the prayer of learned advocate, representing respondent number 1.
Respondent number 1.
To comply the order dated 19/5/2025, next date be fixed on 16th of September.
Great.
No further time will be granted.
Yes.
16th of September, my lord, my senior will not be available.
Next.
Amar upor direction. 66.
अब तो 2 PM नहीं तो
66 টা তারপর অপোজিশন কোনটাতে আমি বারবার বলি ওই যে 255
In this matter, I am for the respondent. Last occasion, your lordship giving us chance to file the.
My lord, in this
original
matter, I am
report as per
appearing on
your-
behalf of the
But
petitioner.
already, my lord, in this matter, I have filed two affidavit. Dada, আমি এক মিনিট বলে নিই। Two affidavit as per your lordship's direction, pertaining to some documents which have been sought for by your lordship. My lord, regarding your lordship's order, my lord, I am.
The original record?
My lord, this is the communication given to me by the CDPO.
This is that Kuch Bihar matter?
No,
No,
Birbhum.
Birbhum.
My lord, regarding this is
একটা
the
দাও আমাকে।
communication. কোনো জেরক্স আমার কাছে নিয়ে একটাই কপি ওরা পাঠিয়েছে আমি দিয়ে দিই।
পয়সা খুব অভাব গভর্নমেন্টের।
আমি জানি না এটা কি আছে না আছে। ওরা বলেছে কোনো অরিজিনাল ডকুমেন্টস ওদের কাছে নেই।
নেই তো কি করি অ্যাপয়েন্টমেন্ট দিল?
আমি জানি না। অ্যাপয়েন্টমেন্ট অনেক আগে হয়ে গেছে। তুমি এসছো অনেক পরে 2016, এটা 2010-এর কেস।
আছে, সব আছে তোমার কাছে, আর বেশি চিন্তা নাই।
বাজে কথা বলো, আমার কাছে কি থাকবে? আমার কি দরকার আছে? কোর্ট চেয়েছে। নাও মাই লর্ড,
একটা একটা করে ফাইল করুন।
So they don't have anything with them?
My lord, what happens, my lord? If your lordship kindly go through the prayer by the petitioner in his writ petition. And my lord, my learned senior, Mr. Mahato, has already, my lord, placed before your lordship regarding that, as well as, my lord, to place the maintainability of this writ petition, because no pleadings has been made regarding this issue. They have had no locus standi, and my lord, your lordship last occasion directed me to file an affidavit regarding what is his marks and what is the marks of the others. That has already been recorded in your lordships, and my lord, I filed that same. So, my lord, in this regard, my lord, I am saying, my lord, what I have on record, my lord, what have stated me by the CDPO, I have handed over the same.
You file this in the form of an affidavit?
My lord, last occasion your loss.
And of course, he said that copies are there. Maybe the original is not there.
Yes, my lord, copies, my lord.
So you file it along
My
with
lord,
the
I
copy?
have already filed. My lord, this is a bunch of copies your lordships have received.
My question, asking
Two
myself,
affidavits, my lord, I have filed.
original record is not there. How the appointment has been given?
My lord, that is not challenge here. Your lordship kindly see the pleadings.
And
You are against some other person to have been appointed.
yes, without
added respondent.
without following the procedure of law.
And in the year
if my
2008, my lord, the
husband
procedure has been
now,
already panel elapsed.
after
Thereafter, in
When did you
2016,
file
this
the
writ petition has
petition?
been filed.
2016.
16.
Yes, my lord.
So what were you doing for
16, my lord, the appointment
My lord,
was
he
given. 16. My interview was taken in 2010. After 6 years, by manipulating changing the government.
My lord, 2010.
Changing government will give
Yes.
this
My
appointment?
lord, 2010, my lord.
That is happening. That is my case.
Your case should be the marks that you have obtained.
No, that was manipulated.
My lord, that what
In
I have stated in
original,
my application.
no, in original, it is not original. It is manufactured,
When were the results declared?
not declared.
Is declared.
Not declared at all.
Probably, my lord, it is-
Not
it is
declared at all.
It is not correct. My lord, what has happened when the result was published on the affixing on the board, thereafter they have challenged it after 21 days about. Now
The interview was held in the year 2010.
Yes.
And the results were declared in the year 2016.
2000.
Yes.
2015,
years.
3rd February.
After 5 years.
After 5 years.
The court's order.
On the
No.
my lord,
No.
my lord,
Certainly not.
my lordship, kindly hear me for a moment. Now I have stated in my application, whatever they have stated in the writ petition, nothing has been reflected how they have given the examination. What I have stated in my addition of party application. That was allowed. And thereafter, they are taking all these pleas, which are not there in the writ petition. Absolutely
So
beyond the
both
scope
of
of
you
the writ
appeared for the examination in the same year?
I don't know what they have done, but I have appeared categorically. I have annexed all documents, what they have not.
My lord,
In
we
my
have
petition, that's
we
what
have
my additional
annexed
property application
my admit
allowed.
card. We annex the admit card in writ petition, which will be found in the writ petition.
Kindly
That
Okay,
compare
let
the
them file
pleading.
this.
Lordship,
My lord,
kindly compare my additional party application
after
and
5 years,
proposition. Your Lordship
my
will
lord,
find
law
everything.
did not permit
They have
at
not
all.
pleaded anything.
After 5 years, 6 years, they have issued appointment letter without displaying the result.
My lord,
This
they
is
have
my
filed the writ petition
How many
for
posts
the
were there?
66, no, yeah, 76.
How many appeared? How
So many.
people?
So many, 1,000.
Given a malad.
And what was your rank?
My lord, I do not know the
Oh, you
rank.
don't know your rank.
But in the manipulated papers,
So how can you say that it was manipulated?
Yes.
manipulated in the sense,
The list was
no,
published.
the 6 persons.
List was published. The
No.
list of successful candidates was
Yes.
published.
No, never.
Yes, that
No,
was published.
never.
That I have stated in my additional party application.
Maybe.
So your statement is good enough, but have you annexed any document of publication of
That
the
I have
results?
stated that
No.
since the WhatsApp copy couldn't
WhatsApp
be WhatsApp copy, the picture I have taken from the affixed in the office board, that I have taken, and that was WhatsApp. That is not legible, but that record was there. That I have pleaded in my additional party application.
But in
But they have
earlier,
not.
but
They have
in,
not.
but
You
in,
kindly compare their writ petition and my additional party application.
that is another
Behind the
thing.
back, they wanted
That
to
was allowed.
battle all this selection process. Ex
My lord,
party.
in this
Thereafter
matter,
intervened. And
in
then
this matter,
How
coordinate,
many of you are there?
we are 8.
8.
we are 10
You all of you are successful.
successful.
You are now
according to them.
working.
Yes, still I'm working. Still we are working. Everything has been stated by law. It is on record.
And
Whatever I
what
have
about the other?
stated. That
other
I don't know,
66?
because they have not made party. Even order 1 rule 10 application.
What
has not
about
come.
the other 66 if he says that 76 posts were there?
All are
Filled up?
No, no.
no post has not.
72. My lord, it is categorically stated.
So you first file it in the form of the,
This I will file in the form.
the learned advocate representing the
Their report shows the
Petitioner,
72
state.
appointed.
You are for the state, right?
Yes.
I am the added
Respo-
private respondent.
State respondent number? 1, 2.
Number 1, 2, 3, 4.
As a state respondents. 1, 2.
My lord,
One, two,
one
five, and
prayer before lordship.
1 to 5 and 7.
1,
The
2, 5, and 7.
panel should be signed by the, my lord, the recruitment committee.
Acha,
That
the
is the
report
6th
part-
person.
Report placed before the
It has become infructuous.
court by the learned advocate representing the state is to be filed in the form of an affidavit
should
on the
occur.
next date of
Application of
hearing.
result. If the result is
For the
published, it has
submission of
become
learned
infructuous.
advocates representing all the parties, next date be fixed on 18th of September.
18th September.
My lord, at
Yes,
2
what is
PM
your
will-
problem?
No, I have no problem.
Like, at
But
2 PM.
one prayer may I make. If your lordship fix at 2 p.m.
All of you will come and say 2 p.m. So I will start the court from 2 p.m. then.
No, usually.
Well, kindly do
At
this.
2 p.m. Huh.
Grateful to you, Lord.
Grateful Lord.
Next.
18 September.
নামটা দিয়ে দিয়েছি।
আচ্ছা কোনো অ্যাসাইন্ড ম্যাটার বা কিছু আছে?
Two 27, my lord, I appear for the state respondent, my lord.
Yes.
I appear for the petitioner in this matter.
Lord, we have been given a notice that no one was represented
Yes.
by the state respondent, my lord. My lord, I find the directions for affidavit was given on 16th of April 2025, my lord. Further, I find, my lord, on the previous occasion, they have filed a supplementary affidavit. My lord, the learned counsel appearing for the state is no more in the panel, my lord. Mr. Siddiqui was leading in this matter. He's no more in the panel. May I have a copy of the writ petition as well as supplementary
Sir, can you
affidavit, my
give
lord?
him a copy of the writ petition as well as
That
the
facilitates the hearing, will it? I'll certainly give it to him.
And my lord, may I?
because nobody was appearing for state, sir. At
Problem.
least now he has
I'll
appeared.
hand it. I'll hand it.
And my lord, I will kindly extend the time, my lord. We'll come back with the affidavit in opposition, my lord.
Learned advocate representing the petitioner is to serve a copy of the petition as well as
The supplementary affidavit.
upon the learned advocate representing the state who seeks further time to file the affidavit in opposition to the main writ petition as well as
Yeah,
a
supplement.
reply to the supplementary affidavit, if any.
And my reply also, will it?
Next date be fixed on 22nd of August for filing affidavit in opposition as well as reply to the supplementary affidavit. Affidavit in reply to the affidavit in opposition to be filed by the learned advocate representing the petitioner by 12th of September.
As you wish.
A copy of the affidavit in opposition as well as the copy of reply to the supplementary affidavit be served upon the learned advocate representing the petitioner in advance.
We are grateful. my lord.
Next date be fixed on 15th of September.
As you wish.
We remain grateful, my lord.
I'm on behalf of the
But I
petitioner.
appear for the respondent number 10 and 11, the private respondents.
I have petitioner filed lordship exception of the reply submitted by the inspector in charge Malda police station on behalf of the petitioners.
Exception?
Exception.
There was a direction of my lord on 23rd.
Cultivation of land issue.
Yes, my lord, the cultivation of land, my lord, the land was initially, my lord, it was vested. It was thereafter pursuant to order passed under, my lord, the Estates Acquisition Act, divested. My client applied for change of the, my lord, the record of rights. Since the land is recorded in, my lord, number 1 Khatiyan, that is the state's Khatiyan, and a patta was given to my learned friend. My lord, they were trying to, my lord, cultivate. I said, since the land is belonging to me after the divesting, the produce belongs to me. This is, my lord, the sum and substance of the dispute. So, my lord, they are challenging before your lordship, my lord, about, my lord, the seizure by the police. The police has given the report to say that the seizure was made pursuant to their apprehension that there was a dispute, a civil dispute concerning the owner of the produce. And, my lord, they have kept, my lord, this under the jimma of a particular person.
So must have perished by now.
Lord, that I do not know. The Lord, it
What
is a
was it
paddy.
of?
It was a paddy.
My simple prayer is kindly direct to return the paddies and what they have seized, police seized, and protection to
State is
cultivate
being represented by
The state,
lively-
Lord, Mr. Devangshu Dinda, Lord, he had appeared. And Lord, since there is a Lord, a dispute about, and this particular document has to be disclosed, Lord, we have got it, Lord, in through other sources. Lord, the reason that has been given by the state is contained herein. They say that I'll just read it for your lordship. That Lord, this particular plot of land, which is the subject matter of dispute, Lord, it was Lord initially vested to the state under case number of such and such. Subsequently, that proceeding has been set aside and EA appeal, estate acquisition appeal. Then, Lord, my client had, Lord, applied for, Lord, transfer of his name because it was, Lord, after the vesting recorded in the state's name. That is pending. The change of ROR is, Lord, pending at the end of, Lord, the state government.
so the state should file a report, sir, stating this.
Yes, Lord, this is, Lord, this is very German for the purpose of, Lord, the present status of the land that it has divested. Once it is divested, but the patta cannot continue, and my learned friend cannot claim, Lord, whatever that the produce that has been there to be his, Lord, property.
But do you admit to have engaged him to cultivate
Lord,
the
I did not engage. Lord, the patta was given by the government considering the land to be a vested land. So, Lord, he is not my, Lord, Bhakchashi.
They are
They are claiming
disturbing
As a patta hold is from the state.
position
from the state.
From the state, because state said that it was a vested land
So
initially.
state will be required to.
Yes, yes. And if your lordship desires, my lord, we can also give a opposition, my lord, because there are certain allegations that my learned friend has put in against my client, but we can put that. Basically, this is a civil dispute.
It appears.
This is the civil dispute.
He has come here to seek for the.
But the return of the seized article, for the return of the seized article, he has a remedy before the magistrate.
And protection, lordship, to cultivate the land. Since we are cultivating.
That is the subject matter of dispute. That
they are disturbing.
Come here.
Police disturbing, lordship. They disturbing our peaceful cultivation also through the police by influencing politics.
So you should file appropriate suit before the court for.
They have not produced, lordship, the record of right. They police.
That is exactly here I am trying to produce.
So you asked.
Give me a copy.
No, I'll file it by way of an evidence.
Yes, filed. Then filed.
You know the advocate for
Yes,
representing the state.
Mr. Dindamla. Yes.
So
On the last
adjournment
occasion.
for today, then you get him tomorrow. Ask him
My lord.
tomorrow.
My lord.
And
Mr.
I have
was appealed.
Petitioners have told everything in exceptions, lordship.
Sir, how far your petition can be entertained, that also needs to be seen.
Yes, yes.
You have come here for.
The return of a seized article,
For
if he has a
protection,
case, he has to go before the magistrate and ask for that because not a case has been
The
registered.
police can't.
What is your prayer?
seize, lordship. Protection, lordship.
Protection.
Peaceful protection for peaceful cultivation of the land and return of the paddies also.
Yes, for the return of the paddies.
Hear out the
inquiry,
state and
because
thereafter.
political-
Lordship.
Political
That's it.
persons are involved, lordship.
No,
Influential person is involved
So
in
that
this
is
case.
your main contention.
Not main contention. I am being harassed continuously. Petitioners are being harassed.
So
and
you
threatened.
filed a complaint before the police.
Only protection, lordship. I have filed. They have not taken any action.
Let the state come and say so. That he
This-
has filed a complaint and the police has not acted upon it.
Protection should be
You heard
granted.
the submission of learned advocates representing the petitioner as well as respondent number 10 and 11.
10 and 11.
None appear to represent the respondent state. Let the matter be adjourned for the day.
Prayers.
So you ensure the presence of.
How we can inform? I can ask my advocate on record to give him a written notice.
Or else then again have to ask the
Lord,
GP to come and all. The exception to the reports submitted by the inspector in charge, Malda Police Station, filed by the learned advocate representing the petitioner, be kept on record. Have you received a copy of this exception?
My lord, yes, today.
A copy of the same has been served upon the learned advocate representing respondent number 11 and 12. Next.
But may it be, Lord, on Wednesday, because Lord, 1 day's time may be required for him to give the notice and Lord. If it comments to your
31st
lordship.
of July.
Lordship.
31st of July.
I'm grateful. আজকের মধ্যে পারলে দিয়ে দেবে
আচ্ছা তাহলে ওই
Grateful. না আমি কালকে দিচ্ছি
আর কিছু আছে ওল্ড ম্যাটার এখন করতে 8টা হ্যাঁ ঠিক আছে। Sir, are you there for Union of India? Oh, Ashwin. None appear to represent either of the parties. Let the matter be dismissed for default. Huh. Ever for orders to.
My lord, I'm praying for a short passover, my lord. Learned Senior Counsel, Mr. Nilanjan Bhattacharya is engaged in another court, my lord. A short, very short passover, my lord.
This is that 163A matter.
No, my lord, this is 166, my lord. As far as quantum is concerned, my lord, I don't have anything much to say. So whether Mr. Bhattacharya comes or not, my lord, he hasn't got much to gain. Appeal would be disposed of without any, my lord, difference being made to the quantum. I was only praying the right to recover on the ground that the victim, my lord, the vehicle was not having a route permit. It wasn't having a registration certificate. It's an amputation case, my lord. Award of approximately 20 lakhs, my lord, 19 lakh 36,500 was passed.
Record. Did they file any cross objection?
No.
Evidence?
My lord, evidence, my lord, the specific evidence on which I was relying upon, my lord, is at page number 48, my lord, is by the Deputy Secretary of the State Transport Authority. My lord, that was on the point of route permit, my lord. Page 48 of my lord's paper book.
When did the accident
My lord,
occur?
on 25th March 2009.
20?
5th, 25. And my lord, I'll also invite your lordship, my lord, to the charge sheet, which is at, my lord, page number 48, my lord, page 48, and the charge sheet, my lord, was at page number 100. What was it? Page 6, my lord, part 2. Your lordship will kindly come to, my lord, page number 11.
Next, আরেকটা আছে না? Paper book আরেকটা আছে?
No, my lord, in this has been divided into part A, part B, my lord. The second half is, my lord, of part 2. This page number 11.
Page number 11?
11, my lord, yes, lordship will see, my lord, kindly. It's a handwritten, my lord, the charge sheet, it is there, the part of charge sheet. Charge sheet is started, my lord, at page number 6, my lord, I was inviting a lordship to page number 11. My lord, the last 3 lines handwritten.
Yes.
My lord, it is against the offending, my lord, truck, which is, my lord, refers to video so and so, 66929 dated 31st May 2009 under section 192 and 197 of Motor Vehicle Act. My lord, section 192, my lord, it speaks about, my lord, the vehicle is flying without registration. My lord, this 192 is without registration, means, my lord, the vehicle, my lord, was without having
192 and 197.
My lord, 197 is without authority. My lord, I'm not specifying on 197, but on 192, my lord, is when 192, my lord, is without registration. My lord, since the vehicle, my lord, was not having the route permit, my lord, so registration deemed to not to have been there. So, my lord, this is the police's report. My lord, I have shown your lordship, my lord.
But in page number 48,
lordship,
you have just now shown.
Yes.
It speaks about
Route permit.
Route permit.
Lordship.
And what about registration?
My lord, registration, my lord, when the route permit is not there, my lord, registration is deemed to be ineffective. So, my lord, 192 read with, my lord, this evidence of, my lord, the State Transport Authority that the route permit was not there. My lord, I was praying that your lordship, my lord, will kindly grant me right to recover. My lord, as far as the quantum is concerned, my lord, it's a double amputation case. My lord, a homemaker, 52-year-old lady, my lord, she was going pillion on a scooter, my lord. She was hit by a truck, and my lord, she lost, my lord, one leg below knee, one leg, my lord, above knee, and award of 19 lakh 36,500 was passed. Is the accident of 2009, my lord. So, my lord, as far as the quantum is concerned, even though, my lord, there are certain issues, but your lordship, my lord, taking the totality of it, my lord, I will not be, my lord, praying anything.
No, but what is your main issue in the appeal?
My lord, in the appeal, my lord, it's a route permit.
Route permit.
Route permit. My lord, I have taken the point of quantum also, my lord, but I will not press, your lordship will kindly not record my statement, my lord. Double amputation case, my lord, I will not argue on quantum. 19 lakh 36,500, that was the total compensation. मुझे My lord, in this case, I have only deposited the principal awarded sum of 19,56,000. I'm grateful.
Next.
I'm appealing with the appellant, my lord. This is a case under section 166, my lord. This is the injury case, my lord. 8 years boy, my lord, has become disabled to the extent of 40%. My lord, kindly see page 26, my lord, as to why.
Page
26 of the paper book. The multiplier method has not been accepted in calculating the compensation amount. My lord, kindly see page 26, third paragraph. Starting from, my lord, in this context, I am of the view that since the victim Biswamay Jana, aged about 80 or 6 months, had no monthly income at the relevant period of time, there is no scope to consider the percentage of disablement for computation of compensation. My lord, notional income has to be taken into consideration. Thereafter,
monthly income, what is the percentage of disablement?
40%.
Where is it?
My lord, medical board, page 112, my lord. 112 page. And my lord, the doctor has come and proved.
What has happened?
My lord,
shortening of left leg.
Yes, my lord. Ankle, steep of left ankle, and permanent disability, my lord, 40%. And the medical board who has come, my lord, page, my lord, 16. Page 16, the deposition. PW2. 17 medical expenses. Yes. Accident took place in the year, my lord, 2014. my lord, 21st November 2014. My lord, your lordship knows that, and in earlier occasion also, you also in calculating the compensation amount taken, my lord, minimum wages.
My lord, may I? শেষ করে না।
And here,
My lord,
thereafter, no, দাঁড়ান না, বলে দিই এখানটা, my lord.
বলে দাও।
My lord. Notional income, my lord, has to be taken.
Senior boy was my, yes.
And my lord, kindly see thereafter, my lord, page 26 again.
It is not on the server yet.
Thereafter, only 2 lakh, my lord, lump sum has been given, and medical expenses has been given, my lord, and 5,000 has been given grievous injury only. That was my matter. My matter was Muslima Bibi. My lord, taken. My lord, that was, my lord, death case. That was death case. Muslima Bibi, yes. Yes, my lord.
Lord, may I? Lord, this is again, my lord, one of those cases where the chance is being taken. 8 chance is being taken, my lord, if enhancement can be made. My lord has been kind enough, my lord, to see the disablement certificate, page number 112. It is a fracture injury.
No, it's a shortening of
Shortening
leg.
of leg, yes, my lord. Shortening of leg because of fracture injury, my lord. What is the problem, my lord, is that it's a stiff left ankle. Your lordship will kindly say, my lord.
Left ankle
A
and
stiff left.
permanent.
আচ্ছা তুমি বলে না আবার বলতে থাকো না
ঠিক আছে,
বলে
বলুন।
শেষ করো no let him finish my lord otherwise again every time he'll start
No, he
Your
will
lordship, my lord,
continue.
yes.
So I know how to handle you.
my lord
will say.
this is
These 2 decisions, my lord, your lordship consider this is, my lord.
Finished. Now you keep shut. Yes, sir.
my lord this is a stiff left ankle the 8-year-old school boy my lord learned tribunal judge awarded my lord 4,49,000. Of course, my lord, more than 2 lakhs were for the medical expenses, and the balance is, my lord, for the loss of income of this 8-year-old boy. 40%, my lord, this is injury was, my lord, was confined to, my lord, the leg, one leg of the left leg of the boy.
Yes. Now you will
And
go
now
back to.
I'll go back, my lord. Yes, of course, I'll go back. I'll go back to the last Supreme Court.
So
My lord,
now-
first,
বলে নিন, ঠিক আছে, বলেন।
my lord, first of all, my lord, this functional disability, my lord, this is the primary, most fundamental, that to decide what is functional disability. This medical board, my lord, it never goes, my lord, this onus is upon the, my lord, Supreme Court says is upon the honorable courts or learned tribunal to decide what is the functional disability. My lord has seen this extent of injury. My lord, now, your lordship will kindly, my lord, if I invite my lord to page number 45, lord, this is the subsequent to the injury and my lord, the disablement certificate, kindly, my lord, page number 45, the doctor who was treating this boy after this injury, my lord, in the middle on the right side, my lord, it is written fit to join the school. My lord, you've got 2.5 lakhs. Functional disability, my lord, has to be decided, my lord, it is 5%, 10%, 20%, whatever that is. And then, my lord, admittedly, the boy of no income. My lord, Supreme Court in last 2-3 judgments has taken, my lord, the notional income to be the, my lord, to be as minimum wages. After that, my lord has disposed of a number of matters, my lord, 25,000-30,000 rupees per annum, my lord, that notional income of a boy. And prior to that, my lord, scores of matters have been disposed of, my lord, with a notional income of 25,000 to 30,000 rupees per annum. This is what, my lord says, because in the homemaker case also, my lord, 3,000, 4,000, 5,000, 6,000. This is what, my lord, is deciding. 8-year-old boy who suffers 40% permanent disability, whose injury is confined to left leg, and with stiff left ankle, of course, shortening, my lord, of
Did the
left leg is
tribunal
there.
say? Tribunal did not consider.
Did not consider, my lord. Only lump sum has been given.
No, did not consider. What is the reason?
Well, that reason only to this extent, my lord, since my lord, victim has got no monthly income, on that basis, my lord, lump sum has been given.
Okay.
More than 2 lakh awarded, and my lord, this the
So
doctor
40%.
10%. My lord, then this is in excess. Your lordship will be directing them to return money to me. This is what the Supreme Court judgment that UP State Transport Corporation says, return the money.
My lord, this is lump sum. My lord, the non-pecuniary damage should be, my lord, victim was indoor patient. That has to be considered also.
Yes, yes.
And my lord, number of judgments has to be considered. Only one judgment, but another number of judgments stated, my lord, the disability which has been stated in the, my lord, disablement certificate.
Lord, this is UP State Road Transport Corporation versus Vibhor. Lord, I'll give it to your lordship. Lord.
That is only one. But number of judgments has to be, my lord. The 3 judges bench decisions also, my lord, Sanjay Verma. No. My lord, they have raised this issue. I have come multiple method has not been taken into consideration. My submission was to this extent.
Lord, what they consider, I'll just simply come up and say that yes, lordship will kindly allow this loot.
I am leaving it before your lordship, my lord.
Lord, he has got more than, my lord, what was required to be paid, 4,50,000 with 8% interest they have received. My lord, that's what, my lord, I borrowed my lord's, my lord, the term, take a chance. Whatever you get, you get. Fit to join school, functional disability not assessed. Injury is confined to only left leg. It is a fracture injury. Yes.
That has been received.
With 8%. They would refund me, Lord. This is what High Court has said. This is what Supreme Court has said.
The insurance company has not raised any, my lord, cause objection.
That is not required, my lord.
Required.
2019? My lord, award is of August 2019, my lord. Maybe some days, some months after that, the deposit must have been made. August 2019. My lord, the loss of income, my lord, was granted, my lord, 2,44,636, and my lord, for the injury, 5,000. Grievous injury, 5,000, that is non-pecuniary. And for loss of income, it's approximately 2.5 lakhs.
No, loss of income, 2 lakh.
Treatment expenses, Baba, 2 lakh diyeche.
2 lakh future posture. My lord, kindly see page 26.
Acha, 2 lakh, 2 lakh. Yes, my lord. My lord, for the income part, 2 lakh. For the non-pecuniary part, 2.
No, not only income, my lord. Future prospect, not income part. Only future prospect. My lord, kindly see in this situation, keeping in mind future prospect of the victim. My middle portion, 5,000.
না ঠিক আছে মেডিকেল এক্সপেন্সেস 2,44,000 2 লাখ ইনকামের জন্য আর 5,000 ইনজুরি
Future prospect.
আরে यार ইনকাম ইজ ফিউচার ইনকাম পাস্ট
Future is future prospect only.
Lordship. Lordship. Not on the basis of 30,000 rupees.
Down, my lord. Because 5,000 will be much more higher, my lord.
On the basis
medical
of
expenses, my lord, 2,44,000.
2014. 2014. Lordship. Milord, the maximum Milord is 30,000. Milord, he's 8-year-old. He's an 8-year-old boy. Lordship. 10%. My lord.
No, that should not be, my lord. Because of the fact, my lord, 40% should be given.
Next.
My lord.
Milord, it would be Milord 10. Milord 10%. Lord, it would not cross, Lord, this because, Lord, it is.
No, but
three-
then medicals and medical is.
Lord, even taking that, Lord, even at the rate of 300 rupees per month, 10%. Lord, 3,000, 10%, Lord, that is 300. That's what I say. 300 rupees per month, Lord, per annum is 3,600. So, Lord, they have already got, Lord, more than 2 lakhs. As far as, Lord, the quantum part is concerned, Lord, it would not reach 2 lakh, whichever way I calculate.
It won't.
It won't reach 2 lakh, Lord, this loss of
That
income.
will increase that grievous injury part.
Lord, I'll make, his fees,
That poor fellow.
this poor fellow.
No, that poor fellow. Because he has eaten up his part. But my is not fun.
Lord, I'll make the calculation. Lord, kindly grant me 5 minutes. Lord, Lord, will take up the next matter. Lord, I'll
in the appeal, my lord. First, my lord, the owner of the vehicle violated the terms and condition of the policy and quantum. My lord, first point, my lord, I have not placed, my lord, because it was not proved by through evidence. My lord, only quantum.
First ground what you have taken?
My lord, in the memo of appeal, I taken, my lord.
That's what I'm saying. Just tell me the ground.
Yes.
Non-involvement.
No, no, no. My lord, here, my lord, IMT. My lord, page 20.
Where is your memo of appeal? Which page?
Page 25, my lord, your lordship, see.
So you are saying that the vehicle was not insured.
Four.
So violation of the conditions of insurance policy. Yes, and second is quantum.
Second in quantum.
What happened?
My lord, in this case, it was pleaded that victim was a mason and earned rupees 9,000 per month.
9,000 per month.
9,000 per month.
Accident took place in which year?
Accident
2013. 2013.
2013.
13.
So who all came and deposed? Who
My
came
lord,
and deposed, sir?
one eyewitness who is or
No, about the income part.
income, my lord, wife of the victim.
Wife of the victim.
My lord. PW
One.
PW1 is the
other
son.
Huh?
Son of the victim. Page
Son of
7.
the victim.
Page 7.
So the wife did not come. The son came.
Son came.
Mother also, wife also come. Lordship, claimant number 1 is the wife, Aklema Bibi.
Who came to depose? PW1 is the son of the victim.
Yes, son of the victim.
They have received the money. No.
Yes.
They have received.
No, I have
deposited it.
Lordship, future prospect was not given.
Other day, your lordship told me that 3,000 consider 3,000. And your lordship. And my lord, regarding future prospect. 13.
Lordship, there is 8,000, Lordship. I have the books, Lordship.
My lord. Yes.
84,000.
I have deposited, I can deposit, 8,91,672.
And it comes up to?
8,91,672 with interest, my lord. I have already deposited.
So now with 84,000 and future prospect, how much is it coming to?
Comes 6,18,600. My lord, if any balance, my lord, they can return.
Get full to your lordship.
I am the respondents.
72, your lordship, I am appearing for the petitioner. This is that matter, my lord, where just on gratuity and leave salary was paid for, my lord. Today only one difficulty, my lord, I just missed the brief, my lord. May I only pray for 1 day's accommodation, your lordship.
On the last occasion, I have already stated, my lord, your lordship can pass the order, my lord, 6%, 6 months. That's the standard order passed by this.
I have also passed one, I have also handed over a copy of.
Okay.
At this minute, thousands of orders are passed by this honorable court. I don't mind. 6%, 6 months, your lordship passed under. For interest on gratuity on delayed payment. Principal amount we have already paid. He is not paying for interest for delayed payment. So 6%, 6 months.
For
6 months. That's the order passed by this.
And my lord, if they fails to pay within the 6 period, which is to be
No.
paying.
Now we are paying. No fail. My lord, there is no question of ifs and buts.
That order it has been
Then
mentioned.
if
Then
they
10%.
fail,
It will be 10%.
What now?
Well, it's,
They fail, then you file.
it's a money claim. I am admitting 6%, 6 months.
Okay, sir.
My lord, one order I have already handed over to the court officer, my lord, for perusal of this.
Anyway,
A coordinate bench order, my lord, similar matter, my lord, I have already given.
So what do you want? You want it to be dictated tomorrow?
My lord, if that.
As your lordship, my lord, I don't mind. My lord, I have
Your lordship's convenience.
because so many orders passed by this honorable court, each and every court, directing my clients
So
to.
he says he doesn't have the brief.
The brief, my lord.
That's my largest concern, my lord. If your lordship pass an order, your lordship can pass this order. I don't mind. The standard order is, my lord.
Later that this can be disposed of.
Yes, as your lordship.
My lord, subject.
We have paid everything.
My lord, that I have to see, my lord. Kindly keeps the matter, my lord, tomorrow or subject to any other time, my lord. I don't remember the, my lord.
Because the list of dates you have written for interest on gratuity and leave salary.
Lord, then I have received the principal amounts on gratuity and leave salary, my lord. If that has been pleaded, my lord, then there is nothing beyond the pleadings.
So he's seeking interest on the leave salary also.
Yes, he is entitled. He is entitled. My lord, subject to the conditions passed by, the order passed by this honorable court, my lord. On the
In only those cases where the petitioners have
quarter fees.
Not vacated the quarter. My lord, that is not the case, my lord, in this matter.
No, no.
Submitting that.
I am yes, my lord, all the matters, these honor.
I am seeking for 1 day's day for accommodation. Let my learned friend come tomorrow.
One 174, my lord. Mr. Devanjan Mukherjee is appearing for Cholamandalam. He's on his legs, my lord. Yes, my lord. Court number 3.
Yep. I have come before your lordship only twofold ground, my lord. Whether auditor's report has to be taken into consideration, auditor's report regarding income of the victim, whether that has to be taken into consideration or not. And another is, my lord, the 10% will be added toward, my lord, on the conventional head. Only to this ground, my lord, I have come. Auditor has come and proved his income by filing, my lord, audit report. That has
Which
been
page?
exhibit 8 and 9. Page, my lord, 15. Page 15. My lord, auditor has come. PW3.
Yes.
Thereafter, my lord,
Now, if the auditor's report is there, the ITR is not there.
ITR is not there.
Why?
Because, my lord, this was not taxable income. For that reason, the income tax return has not been filed.
Now, when did the auditor produce the report? After the accident?
My lord, kindly see page 54.
Page
54, my lord. Accident took place in the year 2012. And this is the last audit report. Thereafter, that is exhibit 10. My lord, page 54, this is audit report. Thereafter, my lord, balance sheet. Page 55 is the balance sheet. And according to my lord, profit and loss account, the net profit of the business was 1,58,930. And the tribunal below, my lord, in this regard, I also, my lord, submitted one decisions. The audit report, my lord, has taken into consideration. Page 1 of my compilation, paragraph, my lord, 10, 9 to my lord 12, your lordships will find. In our page 4 of my compilation, my lord.
Chartered accountant had appeared.
Yes, ma'am. Chartered accountant had appeared, my lord. Page 15, my lord. Page 15.
Page?
Page 15 of the PW3. My lord, second line.
Now, you have shown me the exhibit. Now, show me his deposition, the deposition of the auditor. I mean, the chartered accountant.
My lord, page 15.
1-5.
1-5.
He was cross-examined.
Yes, my lord.
What amount did the
my lord, 1,58,000 gross.
No, what did the tribunal consider?
Tribunal taken, my lord, 9,000 something, my lord, according to minimum wages.
Now, see the cross-examination. What is a cross-examination? This day, I did not bring any document in regard to my identification. Right. So, who is this person? No one knows. Our farm is a sole proprietorship concern.
Yes, my lord.
Where is the document?
Yes, my lord.
In my report, it is not mentioned what are the documents of the business run by Amit Ridash. I had consulted to prepare my report for my satisfaction. I also audited the transaction of business of said Ruidas. The document what assessee or the auditee placed, on that basis we used to prepare our report. It is not possible for me to show that I had testified the authenticity of the documents auditee placed before us for our audit. I dispute that without making any audit, whatever. My report does not show that whether my client Amit Ridas or his firm possessed any PAN card to run his business or not?
My lord, business, my lord, this is proprietorship business. My lord,
So you have not filed the ITR.
No.
So proprietorship business just by your verbal assertion will not gain ground.
my lord, I have received entire compensation 13 lakhs 19,160. 2012.
And also that they could not produce the
দেখেছেন ওটা দেখেছেন
My lord.
And but the fact of the case is that the deceased victim was the driver.
Rupees 10,000 to be reduced.
Yes.
The accident was of 2021. Only issue of quantum, that is what you had said.
And 88,000 was paid extra towards filial consortium.
Huh?
88,000 extra paid towards filial consortium.
This will be 2021. So consortium will be 77,000.
Was parental not filial, parental.
Parental filial.
So
Parental is separate, filial is separate.
now loss of consortium will be accident 2021 and 70 and 10%. 77,000. And now tell me, what about why 10,000 is to be reduced?
Because there is no evidence.
What was he doing?
It is
What
claimed
was he
that,
doing?
Claimed that he was the driver.
Driver of
a victim vehicle.
victim vehicle?
Yes, driver of a victim vehicle. Two vehicles were involved. The case is that the truck, he was driving a truck while changing the tires. But another vehicle, the offending vehicle, dashed him. That is their case. But here,
No, the other vehicle was damaged?
No.
Then why are you saying victim vehicle?
Victim vehicle, not vehicle. He was on road. That he was on road. Now question is driver. There is no evidence regarding employee-employee relationship because nobody has come forward at any evidence.
Who deposed?
Regarding income, nobody.
No, for the on behalf of the claimants.
Father.
Father. Where is the father?
Father's deposition, that page 14.
How did the tribunal deal with it? They had claimed 20,000.
20,000. Since no failed to adduce any evidence, you will find that 75 at page 75 the findings of the learned tribunal regarding income is 75.
75.
75. But employer has not adduced any evidence regarding the employment and a DL, a copy of DL was exhibited, not the original. Copy of driving license of the deceased was exhibited, but on being asked, the father said, "Yes, I shall produce the original driving license of my son," but it was never produced before the learned tribunal. Page 16 is the cross-examination procedure. Lordship will find. In fact, the PW2, the IU test, claimed to be the helper of said truck. He has not also said what was.
Did you ask him?
No.
You didn't ask him.
In fact, he has not asked.
No, you didn't ask him.
Anyway, onus upon them to prove their income.
Which page?
Eyewitness, page 17, 18 and 19.
Now in examination in chief, he has stated in paragraph 4, the eyewitness, that on 28/5/2021, the deceased being a driver of a truck bearing number such and such.
Yes.
Then?
Yes, driver of a.
Then what do you want? You said he was the helper. So the helper says that he was the driver of the truck.
Yes.
Then
kindly come to cross-examination portion.
At the time of the accident, I was the helper of the same truck, and I had seen the accident.
I have seen,
Then what is your problem?
Page 19.
No suggestion that.
They have no document to show. The helper and the,
Let me go on.
who is Dayanand?
Dayanand is the employer.
He has not come.
He has not come. The father says Dayanand is the employer. The helper also says Dayanand is the employer. There is no suggestion that he was not the driver of the vehicle.
The incident occurred on such and such. At the relevant time, I was at the nearby tea stall. The deceased was alone repairing the damage.
I worked with the deceased for 2-3 years.
Then,
Nothing doing.
After the accident, I found the deceased lying under the opening truck. I accompanied the deceased to the hospital. I told the doctor the name of the deceased. Income?
Kindly, ওইটা দে, ওইটা দে, ওইটা দে। কেন বলতে 2021 বলে?
In fact, kindly. No, my lord, kindly see that. My lord.
But if your lordship takes Pranay Sethi into account, then it should be 44,000. 10% has to increase. Even 2021 accident, 2024, the judgment is coming. More than 3 years. According to Pranay Sethi, it has been come. No, but I kindly just take the computation by the learned judge. I don't think there is any error as he is pointing out. Kindly, my lord, kindly humor me for a moment. Kindly come to page 76. So the learned judge has taken 10,000 as notional income. He has added 40% as future prospect, 14,000. Then 1/4, 3,500. Two children, my lord. Compensation on 10,500 into 12 into 16. Besides, I had 16,500 estate. Rupees 1 lakh and as loss of spousal control, 88,000 as loss of parental. There are two children.
Some, only
জল নেই এখানে তোমার একটু জল দিতে পারো তো
এই এই
Hello, I'm for the insurance company. This one.
yes
My lord, in this matter, Lordship was pleased to grant him 500 on the last occasion. Now he's
500
yes, he is pressing for 1,000.
Lordship, kindly
500
see.
1000
Here, no, Lordship, kindly see. Here, the accident took place on 4th August 2016. The learned tribunal assessed the compensation by considering the monthly of deceased 5,000.
oh this is in
That one.
context with Mr. Rahman's case
Yes, Lordship, the context of Ms. Rahman's case. So, Lordship,
oh
I have
that is
come
how
before your
500
Yes, yes, yes.
Yes,
right.
Lordship. Also, I have come before your Lordship with the appeal that there is the wife and the daughter are the claimant before your Lordship. So, Lordship, if the Lolly Tribunal already awarded us 5,96,000, it means the round of loss is 6,000. Then, Lordship, the interest will come 4,800. So, how the person will survive? It's true that the money cannot compensate the human life, but even then, Lordship, I have come with some circular subject to consideration of Lordship.
What
in
circular?
2000 Minimum Wages Act under the circular 2016 Lordship. If Lordship considers unskilled labor, Zone B, obviously Zone B, zone is Lordship the corporation area. It is the not corporation area. So 6,634. That is the unskilled labor, Lordship. So, Lordship, only
why have you come for enhancement
for enhancement.
what
Only
did the tribunal consider
5,000.
5,000.
tribunal considered 5,000
Lordship.
Lordship, kindly see.
sir wait
Lordship, kindly come to page 45.
when was the accident
45.
taken
4/8,
place?
2016.
2016 so what were you doing
He was
Hey,
the
what did you claim to be doing
6,000.
what were you doing
Yes, he's the hawker newspaper seller. So, Lordship, how
this is which district
district, Lordship?
district wise the avocation changes occurred
Puro Medinipur, Lordship. Puro Medinipur.
so if
Puro
it is
Medinipur.
Poshchin then it's Mason and then if it is Purbo then Hawker newspaper
Lordship.
So, Lordship, kindly consider this aspect, Lordship.
then
Kindly that
what you have given a specific
no certificate, nothing.
Nothing is
Nothing.
no you have claimed a Hawker newspaper so it is based on commission
Lordship, is sometimes is based on commission. Newspaper selling is that one of the agent is collecting the papers from the company, and after that he is given some employment to the para people. Those are circulating the papers door to door. So exactly, they are not actually employee. They can there is an unorganized sector. Their name and there is no identity in for the employer. So they are only the employer collect the some peoples to circulate the papers door to door. So that is the status of the deceased. So, Lordship,
so you have come only for this
Lordship,
you have come only for this
I come only, nothing more.
and what was Mr. Rahman's case the other day what was he doing
Mrs. Rahman's businessman.
businessman
Yes, Lordship. So my status is lesser than that. My status is lesser than that. Businessman to paper seller hawker. Yes, Lordship. So, Lordship, kindly 6,000 is my humble request. And Lordship, I now no other issue. There is no issue at all other. So I will not do anything, Lordship. So, Lordship, kindly see that circular. Lordship, kindly see that for a moment. But just sharing my mind, Lordship, that the 2001, the Supreme Court assessed the switch to the 5,000 per month, Lordship. 2001. 2001, Lordship. 2016 লসি 5000 লসি চালের দাম 60 টাকা লসি 6000 লসি কাইন্ডলি আমার একটা ব্যাপার আছে না বলতে তো হবে আমাকে কি
Yes.
Status. But lordship, my lord, খাবার তো একই লাগবে না? Yes, lordship, I said 6,500, I have 6,000, that I've said, that I've submitted before your lordship. No, lordship, that ratio, I am not with that ratio.
Yes.
No, ratio, lordship, according to the Lordship, kindly see the how the wife will maintain herself in throughout the life, lordship. So, lordship, the learned tribunal already granted 5,96,000, a round of 6,000. So now if the fixed deposit rate this is 6%, 6% or 7%, then around is 3,500 per month is earning from as interest. So, lordship, kindly if lordship accepts 1,000. So, lordship, I think the Mr. Chakraborty's client will not oppose, and I leave it to your lordship. Lordship, I calculate 6,000, lordship. If lordship will direct, otherwise I will not. Wife and daughter, lordship.
And how many carrots did you have, Mr. Rahman? Six.
Yes.
And your year of
So, lordship decided the case in 2025.
Then what?
2015.
Lordship decided the case in 2025. That was their judgment of Supreme Court. Yes, lordship. That's true, lordship. But lordship, today you will go to the market and purchase on the rate of the market value. So kindly. Yes, lordship. So we cannot say that.
Yes, but
And if
I'm getting.
500 টাকার জন্য আমাকে আর
করে দিন, এটাতে কোনো ক্যালকুলেশন তো নেই।
It's a death case. An award of 29 lakhs 49,929 in principal was passed against the death of a 47-year-old man, Miller. He was allegedly a businessman. The appeal has been filed mainly on the ground of non-involvement vehicle, non-involvement of the vehicle. 43 days after the accident, for the first time, the matter was brought to the notice of the police, wherein the offending vehicle was numbered. This 43 days after the accident, when the police station was hardly a 5-minute walk from the place of residence of the claimant. So this was one of the reasons that why 43 days delay has been there. Although on the flip side, the charge sheet, eyewitness, they are against me. And as far as the insurance company
Complaint,
didn't complain for the first time, that was
did the complaint cite any
Page 21.
explanation
Page 21.
for reasoning the delay?
আমার স্বামীর অকাল মৃত্যুতে আমার মনের অবস্থা ও শারীরিক অবস্থা ঠিক না থাকার জন্য এবং ছেলের শারীরিক চিকিৎসার কাজে ব্যস্ত থাকার জন্য অভিযোগ জানাতে দেরি হইল। This is the explanation, my lord.
So this is your only ground?
I have also taken the ground, that the victim, was there was a, he has a dual income, one from the business and other from the house property. The total the annual income as per the income tax return filed prior to the death admittedly was 2,65,840. This out of this 2,65,000 house property income was approximately 8,600. That is very minimal 8,600. So that from that part there was no loss of income. Supreme Court's judgment is there that loss of house properties income is no loss. But as far as the other part is concerned, victim used to do the business of hiring of vehicle. He had certain vehicle, he used to give them on hire. Now the question of managerial loss comes in. Whether after his death, the vehicle which he used to give on hire, which the widow admits that her husband used to earn by giving vehicle on hire, whether she suffers actually that particular amount of loss or not. But this is a little vague. There are absolutely specific elements are not there. But the fact is that 8,600 was the income from house property, and the vehicle which the income of the victim through business was by giving.
You mean to say that the income from the house property is still there and is being enjoyed by the? This is what you say.
This is what I say. Yes, I'm grateful to your lordship, and not as far as the income from the.
But
Giving vehicles on hire.
Is there any evidence to that effect?
Evidence, as far as the income tax return is concerned, it says it is divided into two parts. The first part is the major chunk is the income from the business, that is the and then the income from house property, that is 8,000 odd rupees. These are there.
Now, what do you mean by income from the house property? That is not whether income from the house property was to be deducted or not.
There is one Supreme Court judgment specifically on that. The income from the house property is to be deducted because that is not to be considered as loss of income or loss of dependency for the claimants who are surviving.
So that's what I'm saying. Whether the income of 8,600 is still being received by the
claimants, surviving claimants.
This would have been a relevant question had they put it to cross-examination. The victim, the income tax authorities, no one was asked this question. This is for the first time in the appellate stage this question has come, and they have argued this point without any issues being framed. At page 54, my lord, page 54 of the paper book, this issue has been discussed in elaborately. Page 54, second paragraph. The income, how the court has arrived at it.
You have taken this ground in your memo of appeal.
My lord, ground is there. Yes.
But there are valid reasons here, sir. In page 54.
Lordship.
Yes. Oh, just point deletion, huh?
Tomorrow, Lordship.
We'll continue tomorrow.
Lordship. Lordship. My lord, tomorrow, my lord, after Lordship will take up for orders matters, my lord.
Let us finish it for today. How many did we do? 9, I believe.
No, 5.
Nah?
What all?
166, 168, 170, 171, 172, 174, 175, 178. 9. So we did 9. We could have finished it up. I have an.
Lordship,
I have to
tomorrow.
go for a meeting.
Like today, my lord, tomorrow we will continue with this for orders.
Yes.
Get put,
Let us finish
But
the
as many as
for orders first. By tomorrow, I think by Wednesday we'll regularize. But tomorrow there's a full court reference.
My lord, full court reference is on Wednesday.
Wednesday.
Yes, please.
Okay. 30th, no? I'm
Yes,
sorry.
yes.
30th.
Wednesday.
So tomorrow we'll
Continue with this for orders.
continue. For
Lordship.
so today there were kota chilo aske? Okay. Anyway, by this
Anyway,
week, we'll finish it.
Lordship. Bless.